just kept calling me.
He was on the pizza box case.
And that was the last conversation I had with them. They kept calling. I'm like, you need to, instead of calling me, you need to call him and tell him to file withdrawal. Okay, good. I tried to call him. I didn't hear anything. So that's fine. I'm gonna.
Oh, no, it's
Is it? I didn't see it on the list. Okay. Cool. She lives in another state. Yep. I remember she testified at first appearance. Do you have the file?
okay. Let's get started. We've got a mixed calendar this morning. We've a little bit of plea and arraignment, some status, I think some probation revocation situations. Ms. Nelson tells me, Mr. Howes, you wanted to try to handle Mr. Lewis's situation first. I don't see Mr. Wright on the call yet, and I'm remembering that he may have had a conflict somewhere else, and we'll get on, but we may not need him depending on what you have to say.
So I thought, and I spoke to Mr. Wright a couple months ago about that this was resolved. We took the plea for Mr. Lewis's 2 indicted cases
In front of Judge Richardson.
Judge Richardson.
Mhm.
And I pulled the transcript, I looked at the transcript, and it said I started out, everything was to run concurrent with his probation revocation. The only thing I did not see at the transcript ends, I do not see at the end of it where the judge actually made a finding that his probation was revoked and
Right. And I don't know if that was your language that Ms. Nelson forwarded to me, or she's also looked at the transcript, but the word I got was that unfortunately they didn't dot the I and cross the T. But if that was the intention of everyone, I'm happy to do that. I would need Mr. Wright when he plugs in to concur.
And that was, yes, that was the deal that I put on the record, and that was the deal that was everyone's intention. However, it appears that since on March 7th of this year, since taking that plea in new probation, that Mr. Lewis picked up a kidnapping, false imprisonment, and aggravated assault charge inside the jail for allegedly wrapping someone in a rug and dragging them across the jail. So the original probation hold was handled. Anticipate another one coming down the pipe.
Got it. But what's on the calendar today, that warrant, and I don't want to get substantive because Mr. Lewis isn't here, nor is Mr. Lewis is here. Mr. Wright's not here yet. But in looking at the probation warrant, it basically is what I'll call the Judge Richardson cases, where the basis for the revocation and the intent of all the parties, Lewis, Wright, you, Judge Richardson, was whatever that sentence was, and those felonies, there's also a concurrent revocation done. It just, that wasn't completed. Seems like we ought to try to do that to address this warrant. But you're sharing news that there may be a new warrant coming.
Yes.
Was the sentence that Judge Richardson handed down one that will keep Mr. Lewis in custody in time for this upcoming warrant, or was it a time served? And so
it was a time served. However, I looked this morning and there's actually been new warrants, actual criminal warrants taken out by the sheriff's office. He has been to first appearance and was given no bond. So those will keep them in custody.
got it. In relation to the carpet kidnapping.
Correct.
Okay. So did the Judge Richardson revocation of this 09 SC case revoke the balance, or it just revoked a piece and there was more on the tail remaining?
It revoked the time that he had served and then continued him on
probation. So it makes sense for us to keep an eye on this 09 SC case.
And the 22 SC cases that he pled to, the final dispositions note that it run concurrent with the 09 probation.
And they included probation as well.
Yes, they included about 4 years of probation followed by 5 years suspended sentence.
Okay, so Mr. Lewis may have business in front of Judge Richardson as well due to the carpet situation.
Yes.
Okay, so it could be 3 judges because that gets indicted. That could go to Judge so-and-so and then Judge Richardson and Judge McBurney.
Yes.
Okay.
I want I've read the warrants. I know what they say. I'm gonna have to do a little digging to see.
Sure. It's a chaotic space, that jail. All right. So what I'll do is when Mr. Wright gets on, we'll have part 2 of the conversation with Mr. Lewis out here.
Okay.
I'm not going to talk about any of this other stuff other than, hey, my understanding was that Judge Richardson had intended to revoke probation in the 09 case on a time served and then reinstate the balance.
Exactly.
And assuming Mr. Wright says that is correct, then this doesn't need to reappear unless and until there's a new warrant. And we'll get Ms. Tucson, who's not on the call yet, to do the revocation.
Wonderful. And I will, if you'll let me go to Judge Carnosale, we're resolving a homicide. We have her courtroom filled with 2 families that really dislike each other. So
Good luck with that.
Yes. And I think, but as soon as that's resolved, I can come back.
Okay,
And,
good. Sounds good.
All right. Thank you, Your Honor.
Yep. Can you, thank you, ping Ms. Tucson? All right. Now we'll go in the published order of the calendar, and position 1 and 2 are your cases, Mr. Florio. It's Mr. Bethea. Good morning. Let's bring him out. Tell me before we bring him out, are you going to be waiving arraignment on his behalf? So maybe he can just be right at the doorway, or?
Judge, we are. This case, he's in the state prison system. He's here on a production order. We started in the non-complex division and he was produced here for a plea and we got sent up here out of non-complex. So I'll speak with Mr. Jordan. There may be a little bit of discovery that we don't have, but I think these cases will more than likely be resolved in the very near future.
Great. You don't think today, though?
I don't think today, just because I think there may be the tail end of discovery that he and I are still looking for. We have the vast majority of discovery on both cases.
From non-complex?
From non-complex.
Okay.
I provided it to him at the jail. He and I've gone through it.
Okay.
I think there may just be a little bit left that we'll take a look at. Mr. Jordan's been kind enough to reach out to me multiple times, extend a plea offer, which would essentially run concurrent with the state sentence he's already serving. So I think we're close.
Okay. Couple thing. Well, let's just get Mr. Bethea at the door. That's okay.
May I approach with our?
Sure.
Thank you so much.
Hey, Mr. Bethea, I'm Judge McBurney. How you doing?
Good, how about yourself?
I'm doing okay. I was just chatting with Mr. Florio about your situation. He shared with me that you're serving a state sentence for a case not out of Fulton County.
That's correct, Judge. He was on probation in Fayette County. These cases, as long as another case he played, violated his probation.
Got it. These cases were in what we call our non-complex division, and they got bumped up to the complex division. I'm one of the judges there. And today's just plea and arraignment. Mr. Florio has already waived arraignment for you, meaning he's entered a plea of not guilty for you in both cases. He also shared with me that you were maybe on the verge of working the cases out when they were in non-complex, and that remains the same. We work cases out all the time. He just wants to get a little more discovery from the prosecutor, Mr. Jordan over there, so I'm nodding his head. So Mr. Jordan will get that to Mr. Florio. I encourage you all to work as quickly as you can because you're staying here until we work these cases out. And my guess is you'd rather be back in the facility we borrowed you from. So we're going to keep you here. Mr. Jordan will get discovery to Mr. Florio. I'm going to enter a scheduling order, which actually maps out all the way to trial, which is months down the road. I will see you as soon as your cases are ready to be worked out. So really, you and your lawyer have the foot on the accelerator. You can wait till trial date, which would be August, September. Or if it is a workoutable case, I'm not saying it has to be, if the state's offering you 100 years to serve on fleeing and attempting to elude, you might well, with a good lawyer, say, I'd rather go to trial than take 100 years. But it doesn't sound like that's how negotiations are going. Any questions about any of that?
No, sir.
Okay, Mr. Jordan, anything from the state?
No, Your Honor.
All right, so we'll enter that scheduling order. Don't despair when you see the dates. We can bring Mr. Bethea over or do a Zoom plea from one of the booths there. As soon as Mr. Florio, you say we're ready to do it, you just let Ms. Nelson know, and we'll get Mr. Bethea on the next available calendar.
Thank you very much.
All right, great. Thank you.
Your Honor, that concludes my business before the court this morning. May we excuse me?
Yes, sir.
Thank you.
While you're walking out, let me ask Mr. Jordan a question. I noticed very small bonds on these two cases. We don't need to worry about that because of, I was wondering, should the bonds be revoked because something has happened? These are old cases. These were arrests from almost 3 years ago.
Yes.
And if something has happened since those bonds were issued, maybe the bond should be revoked. That seems moot because of the revocation.
So Judge, I can tell the court he was revoked for 2 years to serve in the state penitentiary. His 2 years is set to expire in August. That's one of the reasons why he's extremely anxious about trying to resolve these matters with the court and with Mr. Jordan, is because he'd like to get back into the state prison system to hopefully not miss his August release date.
Okay.
And I expect that these matters will be resolved possibly within the next 30 days.
Sounds good. Thank you.
Yes, sir. Your Honor, that concludes my business.
You're still free to go.
Thank you so much, Judge. Have a good day, sir.
All right. Next up is Mr. Alexander, who wrote a letter to the clerk that says Tina and said what he had to say. Signed, Steve. Ms. Feely, your cases?
Yes, and we have a pretty much nailed out plea.
For 3 cases, I think there's one not on the calendar that we had already come across and has a scheduling order.
So we hope to close all 4. There's
4?
the 2 on the calendar, and then 22 SC 183196, and then 22 CP 209163, all shopliftings.
209.
163.
Okay. And that's closing out, in theory, if it goes through with will be NPGJing it or?
Your Honor, or
Okay.
decline, yes.
So we don't need to bring Mr. Alexander out yet. You need to talk with him, but we'll do that this morning. Okay. Just so we don't have a false start, my read of the indictments or accusations in this case is that Mr. Alexander would be looking at a 1-year mandatory sentence. So I wouldn't want there to be a surprise if the recommendation is 3 months and I say that's an illegal sentence. But I'm seeing nodding heads. So you're working through that. You're either to plead to different charges or everyone knows what the statute says, which we're bound by. Yes? Okay, great. So we'll circle back to Mr. Alexander and resolve all that. Fantastic. Donald Young is next. And I don't know, is that I don't know the attorney.
Good morning, Your
You're the
Honor.
attorney.
Yeah, good morning, Your Honor. It's Princess Farazi.
Are you a private practitioner or are you with the public defender's office?
I'm with the Public Defender's Office, Your Honor.
Okay. This is new that it's then not assigned to Ms. Feely or Ms. Wood. Are you in a special unit? You're a special person?
So I'm actually in the pink unit, the pre-indictment unit, Your Honor. I've been assigned to the complex and they've let me handle this particular case.
Fantastic. Well, welcome.
Thank you.
We'll bring Mr. Young out in a moment. It's on for plea and arraignment. I'm looking at is this a Shapiro case?
It is, Judge.
All right. Ms. Sarfarazi, are we waiving arraignment or what are we doing today with Mr. Young?
Yes, Your Honor, we can waive arraignment today. I've already discussed the case with him.
Okay. So if we just bring him to the door, that's okay?
That's fine.
Could we bring Mr. Young right there, please?
And Your Honor, I'll file the waiver form today.
Today is great. We've got him right there on that little shelf.
Oh, I guess I can just do it.
Yeah. I mean, however, you ask Ms. Nelson, she may prefer that you e-file it rather than. Okay, so if you just fill it out, that gets us all the info we need.
Thank you, Your Honor.
So Ms. Feely, Mr. Shapiro, Tutman was a plea yesterday afternoon is my understanding.
That's correct, Judge.
Okay. And we don't have to say alleged anymore. The victim was also in custody. That's why it was in the afternoon, because we had to get the victim over here.
Also correct, Judge.
Hey, Mr. Young. I'm Judge McBurney. How are you?
Hey, how you doing?
I'm doing all right. I was just talking with your lawyer, Ms. Sarfarazi, about next steps in your case. She told me that you're waiving arraignment, which means you're entering a plea of not guilty. And we'll get the prosecutor, the gentleman seated sort of against that little wall right there, Mr. Shapiro, to provide discovery in your case to your lawyer. So that will be the police reports, if there are any statements from witnesses, et cetera. He will provide that to your lawyer. She will then meet with you to share with you what's in that file. So you've got a better sense. I will enter a scheduling order that will set a deadline for any motions that your lawyer may file on your behalf, as well as a trial date. So we keep your case moving along. Any questions about any of that?
No.
Okay. Ms. Sarfarazi will be out to see you soon once she gets that discovery, so that you and she can talk about that, and we'll go from there.
Thank you.
You're welcome.
I'll see you, man.
Before we call the next position, were there any hiccups with the way this trial calendar worked for you two? Or, I mean, you were ready to go and you were going to pick a jury, and Mr. Tutman decided not to do that. Okay, good. Next up is Mr. Camden. And this is on for a status conference, so we should bring him out. So Ms. Sarfarazi, I'm gonna need you can sit one seat back, but the center seat is usually where they like to have the defendant sit.
Yes, sir.
Thank you. And please do make sure you fill out that waiver form before you're doing it now. Great.
I apologize. What was the name?
Last name is Camden, Kamdem.
Have a seat.
Hey, Ms. Rivers, good morning. You ready to go?
Good morning, Judge. Yes, I am.
Great. All right. This is position 6, 22 SC 183536, State versus Edward Camden. And we are handling the status conference in this case. Ms. Feely represents Mr. Camden, and this is Ms. Willingham's case. Whose case is this?
It is actually ADA Hall. I am texting her right now.
Okay. Well, we'll start because I want to hear from Ms. Feely first. Ms. Feely, do you have discovery in the case?
This is one that I think it got served on someone else, but yes, I do now have access to it.
Someone else as in
My office.
your predecessor, or just mistakenly to Fred Smith?
I think it was just mistakenly, but I just went back and checked the emails. I think I do have everything now.
Okay. Are there any evidentiary issues you're aware of? I don't see any motions. It seems like it's something that we could move to a trial calendar.
It is on the trial track, yes.
Okay, great. Anything? I'm opening up Odyssey now just to make sure we're tracking it too. There it is. Okay, so it's on the May 8th trial calendar. You don't see an issue that's not coming too soon in terms of your ability to be prepared.
That's right.
Okay. And is this one, I know it's a little early, that's a few months off, that you foresee as being a trial, or it's a little too soon to know?
It's a trial.
Okay. And Mr. Camden, your lawyer's not committing you to anything. That's her way of communicating to me that you and she have talked. She thinks that there's some strong defenses and or whatever the state is recommending is a recommendation that is more severe than the evidence would justify. So I will see you again somewhere in early May when we call the trial calendar. And you'll have an opportunity when we reach your case to have a jury decide the case. Does that make sense? Yes? Do you have any questions for me? It's okay if you don't. Most questions are for the lawyer anyway, but we just haven't spent much time together. I want to make sure if you've got questions about the process or anything like that, you get a chance to ask.
Yeah, my question would have been about the process, which is kind of really long.
Long. It is a long process. I see how long you've been in jail. And Ms. Feely is working hard on your behalf to get us to that date where decisions will be made about what happens next. And that's what a trial will be all about. That means that 12 people sitting in this space over here will hear the evidence, and the state will have to prove, if they can, your guilt in connection with any of these counts in order for you to stay in jail. If they can't prove your guilt, in other words, if the jury says not guilty, then you are released and can be on your way. But I know it's been a long time, and like you, I'm anxious to get you back into court for that trial, okay? So I will see you next for that. And Ms. Feely will get you back in front of me if there's something else that comes up. Anything else, Ms. Feely, on behalf of Mr. Campbell? You're welcome. All right. So Ms. Willingham, if you hear from Ms. Hall that there's some reason why this case isn't trial ready, let me know. But I'm going to assume the state will be ready to go, given that Mr. Camden's in jail. This is one, and I flagged this more for general consumption. I'm going to have to work with, we are going to have to work with the clerk's office, and I don't know if it's magistrates and maybe the DA's office. Mr. Camden has a bond for two of the counts because when it was a CP case, a magistrate set a bond of $30,000. When it was an indictment, when it was indicted, a serious charge was added for which Mr. Camden has no bond. And I don't know what would happen if he magically came up with the money to post the bond. Would he get out? Would he not get out? No one has made a ruling whether he should have a bond on that third count. It puts the sheriff in a tricky spot. It is uncertain for the defendant. And I worry that there's some folks who can't get out because there was a bond set and the state thinks that's a fine dollar amount. And really what you added with the indictment was a misdemeanor. Well, then the bond probably shouldn't go up. This is the reverse. I think the state would be worried because it added a serious allegation for which there is currently no bond. But I don't know that if Mr. Camden was able to post the bond that had been set, that someone in the system wouldn't say, hey, $30,000, here's a bond. But maybe because it says Alpha Bonding Company, he has posted that bond and he can't get out because of that third charge. I don't know. I just flagged that because I think we keep bumping into these scenarios. Sometimes people will walk in and the state will say, well, the guy doesn't have a bond on this count. Well, but he's out. Apparently someone let him out. So we'll work through that. Okay, Mr. Campbell, I think Mr. Kennedy was, he had a conflict. But I also know from communications from both lawyers, Mr. Jordan, that you and Mr. Kennedy are working towards a non-trial resolution.
That's correct.
And I've explained to you and Mr. Kennedy that Mr. Campbell's case has been added to the next consolidated criminal trial calendar. They'll be down in 1D.
Yes, sir.
Mr. Campbell has been in for 4 digits worth of days. So he will be towards the top of that calendar, but it is sounding like from Mr. Kennedy that it wouldn't be a trial.
That's correct, Your Honor. We are very, very close to a negotiated resolution. There's still discovery issues as those CDs, which contain the surveillance footage and a lot of other things that were served in supplemental discovery to the previous attorney, state's still having a hard time locating that information, but we do understand that the clock is ticking. So we're moving as fast as we can towards a negotiated resolution.
Have you conferred with Ms. McCauley? She was the ADA on top of this case. I remember when we took the plea of the co-defendant. I mean, she knew it up, down, backwards. And I flagged that only because I don't know if she's got her own special stash of CDs.
I reached out, Your Honor, basically after that very first court appearance that we had. I know Deputy McCauley is extremely busy, so I will follow up with her, but I did reach out to her.
Okay. All right.
And if Attorney Kennedy does appear today, if I can just have a brief second, Your Honor, to run back to my office. I do have a CD of at least jail calls that were served in previous discovery that I'll be able to give to him.
Great. Okay.
I wanted to give it to him via evidence.com, but he was having issues with the link. So I'll give him the physical copy in person.
All right. Do we think Mr. Kennedy's coming or his conflict was, I can't be here at all? I can't remember.
He said that later on.
He may come by later on. All right.
He's in the county, expects to report that.
Okay. Coming from Cobb. Can we bring Mr. Campbell to the door, please? Mr. Hamilton is not around. He's in federal custody. I think we've got Ms. Winfrey on the call. That'll be a quick conversation. That's who's next.
Mr. Campbell, come on up.
Hey, Mr. Campbell. Just want to give you an update so you knew why we brought you over here. Today was supposed to be the status conference in your case where I made sure with Mr. Kennedy, your lawyer, that he had all the discovery. He is in Cobb County this morning working with a couple other clients. He'll be down here, I think, later this afternoon. But I did learn from Mr. Jordan, the prosecutor, the latest prosecutor on your case, that he is working with Mr. Kennedy to get the last little bit of discovery. Apparently, there's some surveillance camera footage that they're just trying to get CDs from one person to another. But I wanted you to hear that and this part. I have put your case on a trial calendar for the 2nd and 3rd week of April. So a little less than a month away, in an effort to encourage your lawyer and the prosecutor to think real hard about whether it's a trial or whether this is something that's going to work out. Mr. Kennedy has told me he feels like you and he are getting close to a negotiated resolution with the state. If so, I'm happy to take care of that. Otherwise, you've been in jail forever, and it is time to try this thing if it's not going to be a plea. So my expectation is that that would be kind of mid-April. All right? Any questions? Mr. Kennedy will come see you as soon as he gets a little bit more of this discovery. Thank you. do we need to keep Mr. Campbell up here for Mr. Kennedy, or you're just giving Mr. Kennedy discovery? You're not giving him a new offer where he needs to talk with his client?
No, Your Honor, the last communicated offer would be the same offer for today. We just need to hand him that CD whenever he comes in.
Okay, great, thank you. Next position is Mr. Hamilton, who is in federal custody, and Ms. Winfrey, she was on the call. I guess she had to go. So DA's office, what Ms. Winfrey had shared is that Mr. Hamilton is due to be sentenced in federal court, I think on the 18th of April. And we are keeping this one on warm standby. Ms. Winfrey had represented that assuming the sentencing is a meaningful one in federal court because it is for related conduct, then the state would be null prosing this case. But Mr. Hamilton has been, it's a big number of jail days, but mostly they've been in federal custody, awaiting the resolution of his federal case. So she just got back on.
Good
Okay.
morning, Your Honor. I apologize. I got kicked off.
No problem. I was just relaying to anyone who wanted to listen, my understanding, which is that this case, Mr. Hamilton's case will likely be null pros by the state after the April 18th sentencing, but you, for good reasons, want to make sure that that federal sentencing goes smoothly and that there's a meaningful sentence imposed at the federal level for similar or related conduct. Is that a fair summary?
That is correct, Judge.
Okay. Ms. Feely, is this your case?
It would be.
It would be if Mr. Hamilton ever came back. My hope would be, assuming it's a substantial sentence in the federal system, that this drops away and he does what he needs to do with the Bureau of Prisons. So I guess what we'll do, Ms. Winfrey, is wait to hear from you in late April. Ms. Nelson will probably reach out if we haven't heard anything from you towards the end of April.
Sounds good, Judge.
All right, thank you.
Thank you.
Lawrence Jones is next. He's been in jail for a long time too. Should we bring him out?
If we could not bring him out right now, I'm still working with Mr. Jordan on possibly having a resolution that I can speak with him about.
Okay, sounds good. So we'll keep him here and you'll chat with him.
Just for the record, that case is actually going to be mine, but we can chat about that.
Good. Keep chatting. Don't change a whole lot of what Mr. Jordan said.
Yes.
All right. Jason Hall. Any reason we should not bring him out? Let's bring Mr. Hall out. All right.
What do you want? Come here.
All right, this is position 10, 22 SC 184215, State versus Jason Hall. Mr. Hall is represented by Ms. Feely, who is here with him. Mr. Abate, are you handling this for today? All right, Mr. Abate is here for the state. Mr. Hall, we're going to make sure today that your lawyer has all the discovery, and if she doesn't, what's missing and why, and when can you get it? Because if we're not resolving your case today, we need to get on a trial calendar so we can keep things moving forward. Ms. Feely, what is the discovery landscape in Mr. Hall's case?
I believe I have everything other than I've already spoken with Mr. Abadi about the other clips. There's a ring video that I think is really going to be important and for me and Mr. Hall to discuss, but we have 3 clips that show kind of the shooting and the aftermath, but not the stuff before. So I think that that's going to be a pretty important piece for Mr. Hall and I to discuss going forward. So that's the only thing that I know of that I'm missing.
Okay, it's not government video, it is someone's private Ring camera, but you believe that law enforcement obtained not just shooting and beyond, but they got the whole thing, and for whatever reason, you only have part of it.
I would hope so.
Okay, I'll find out in a minute. I just wanted, because you said Ring, it's someone's home surveillance footage. Okay, but whatever it is, it's not law enforcement, it's not body cam or something like that. Okay, otherwise you feel like you've got the discovery in the case.
Yes, Your Honor.
Okay, Mr. Abate, what do you know about home surveillance footage?
It's my understanding, all the surveillance that we observed is all the surveillance that exists. With the Ring camera, unfortunately, it's motion activated, so it didn't actually activate until after the motion, which was the shooting, where you see the victim fall after he's been shot through the door. So all the footage that we have has been turned over, Your Honor. The only outstanding discovery is the testing from the ballistics expert, which I received preliminarily today, what the finding was, and that was all the shell casings and the projectiles removed from the victim's body all came from the gun that was found inside the apartment, which is alleged to have been the gun the defendant used to shoot the victim. The final report will be published by tomorrow or Thursday.
The person who was shot was on the outside?
Yes.
Shot by someone who was on the inside?
That's correct, Your Honor.
Okay.
I was perusing Odyssey and I did see that the defendant filed a pro se motion for immunity. I believe it was January 23rd of this year. I didn't know if that had been addressed by the court. I know he had a previous hearing on February 7th. It was a bond motion that I think ended a little bit early.
Oh, this is this case?
Yes.
Okay. It's going better so far. We probably need to make a note of that on the calendar, that this case has those issues. Yes, I think, Ms. Feely, you had indicated you were going to take under advisement your client's theory. It would be a little late, but we certainly would need to work through it if you decided to pursue that. Is that something you've decided will be your primary defense, but it doesn't rise to the level of emotion, or where are we?
I think that is pretty accurate, that I don't think it would rise to the level of emotion. However, now may reevaluate that with the understanding that there is no video of the altercation that we believe occurred before the actual shooting.
Okay. My request for the two of you is just confer, as in, look, here's what I've got versus here's what I've got. Just on that narrow area of the Ring video, I have no reason to doubt Mr. Abate didn't give you everything, but sometimes it's like, oh, I didn't realize this file was corrupted or incomplete, or look, my file is 52 megs and yours is 12. So the whole thing didn't I just want to make sure you do have everything, because it sounds like that will be central. And I get why there wouldn't be a lot of the leading up if there wasn't motion. But if someone is coming to the door, it seems like that would activate it, as opposed to only after they're shot and they're falling, it's activated. But I don't have a Ring camera. Don't tell anyone, but I don't. So I'm taking you all as to how those work. I have dogs, so I have a bark. All right. So Mr. Hall, what we're going to do next is see you for trial, assuming, and it sounds like that last bit of discovery, which is forensics, is done, and Ms. Feely will get it plenty in advance. And it also sounds like, not committing her to any theory of the case, it's not surprising either that those were the results. But you are on our May trial calendar. So assuming there isn't something that gets hung up with the home surveillance video, Ms. Feely, this May trial calendar works for you?
Yes.
Okay. And Mr. Abate, your office can be ready for this on that calendar?
I'll be ready.
Okay, great.
I'm going down to APD now. So I will check with the detective to make sure that the only 3 files that we have that are related to video surveillance are the ones that are conserved.
Great.
I'll know that by the end of today.
Sounds good. So Ms. Feely, I'm sorry, I didn't mean to interrupt, but Mr. Abate is doing a double check with APD to make sure he did get everything from them on that video front. So he'll let you know. But I'll assume that we'll be ready to go for that May trial calendar. Okay, Mr. Hall, any questions from me?
No, sir.
Okay. All right, you're in good hands. So should we bring out John Davis, or is that another one you want to talk with the lawyers about?
I got an offer yesterday that I'd like to relay to him. Based on our prior conversations, I don't think that this would be a plea today, but I'd like to talk to him.
Okay. Now we'll do Mr. Brisky, who I have seen on the call. There he is.
In your honor, I'm here for Jared Mitnick. I'm his partner, Chris Howard.
All right. And there is Mr. Brisky. Okay. So Mr. Howard, what we do in these status conferences, we do a couple things. One, I want to make sure that you've got all the discovery in this case. And if you feel like you're missing something, let's discuss.
Your honor, we believe that we have all the discovery in this matter. We received a new plea offer yesterday, which I have merely moments before this hearing communicated to Mr. Brisky. I would just say at this time, I think we still probably need to discuss with Mr. Brisky that offer. And then regarding the discovery that we've gone over, if he's not interested in taking that offer, we would have a motion. I believe that would be filed here shortly, a particularized motion. So I think at this time, we are essentially just asking for a few days here to potentially file a particularized motion and discuss with Mr. Brisky this new offer.
So I haven't worked with you or Mr. Mitnick before, so I'm happy to walk you through this. In November, I entered a scheduling order that set a deadline for the state to provide discovery. If they missed that deadline, the burden was on Mr. Mitnick to let me and the prosecutor know, wait a minute, I'm missing something. You know, the police report says my client gave a statement. I don't have my client's statement. I've seen no discovery deficiencies filed. Importantly, to the schedule you just described, there is a deadline, was a deadline of 2.5 months ago for filing particularized motions. Hold on, let me finish. This case is on a trial calendar that starts in 3 weeks, and it's staying on a trial calendar that starts in 3 weeks. So you can tell me what it is you think you might be filing a motion about, but it's probably not timely unless you're able to say, you know what, I didn't get until yesterday my client's statement, and my motion is to suppress my client's statement. That scenario, you'd be spot on in filing it late because you couldn't have filed it earlier because the state was late. So why don't you walk me through how it is that only now you and Mr. Mitnick would be putting together particularized motions?
Your Honor, I'll be honest with you, I was not aware of the scheduling order, and I generally have not been involved in this case. Mr. Mitnick is currently in Jasper in court right now. I think all we're asking for today is that we have the time to discuss this new offer with our client. Otherwise, we would be ready for trial.
And I didn't mean to put you in the hot seat. You're right. It's Mr. Mitnick's case. You may tell him I'm not sitting in for you again. But just so you and he and Mr. Brisky know, we passed the time for particularized motions again, unless they are premised on late provided discovery. And just looking at these charges, I'm sure hoping that's not what would happen here. Discovery ought to be pretty compact and simple in this case. So,
go ahead.
what I will do is let you all consider that offer for another week, because the second thing we typically do on these status conferences is say, what's the state's final offer? Because if you don't want to take it today, you can always enter a plea later, but you don't have the ability to withdraw your plea if you're unhappy with the sentence. But if you just got this revised offer yesterday and Mr. Mitnick is not in the mix right now because of conflict, then I'm fine giving Mr. Brisky and his legal team a few days to digest what the offer is, to decide whether they want to go forward with that. So what I'm going to do is let Ms. Nelson know, or Mr. Mitnick can do this by next Monday, which would be the 27th, whether Mr. Brisky wants to go forward with the state's offer or not. And the no doesn't mean it won't be a plea in the end. It just means that should there be a plea later on, maybe the day we call the trial calendar, it's one where Mr. Brisky's stuck with whatever sentence he gets. And it may be that I go along with what everyone says. I don't mean to suggest I wouldn't, but that ability to withdraw a plea expires in theory today, but I'm giving you all until next Monday so that you can talk about the state's latest offer. Does that make sense?
Thank you. I appreciate that. Like I said, I think I'm looking here. We got it yesterday around 4:20, so we just really started digesting it. So we will speak with the client. Otherwise, we'll be ready for trial.
All right. Mr. Brisky, do you have any questions about anything we've discussed?
Nothing about what you've discussed. No.
Okay. So I'll make a note that Mr. Mitnick will let Ms. Nelson and Mr. Jordan know no later than close of business Monday about whether they want to go forward with this offer. Otherwise, Mr. Brisky will need to be here, not virtually, and Mr. Mitnick will need to be here, not in Jasper, when we call the trial calendar that Mr. Brisky's case is on. All right?
All right. Thank you, Judge.
All right. Thank you. You both are free to go.
And Your Honor, that's 88 Willingham's case as well.
Oh, really? Okay. All right. Well, there you go. So you have provided an offer to them, and they have until Monday, and they may send something to Mr. Jordan and he'll send it to you. So it didn't jump out at me that it was a DV case.
Your Honor, although I was listening, I missed you saying Mr. Jordan's name altogether, so.
Oh, I just simply said that the email that's going to come by Monday from the defense attorney saying we want the offer or we don't was supposed to go to Mr. Jordan, but it'll go to Ms. Nelson and then we'll let you know.
Yes, Your Honor.
That completes my business. May I be excused, Your Honor?
Yes, sir. And you got the word about our upcoming trial calendar.
I did.
Okay.
Remember that also completes my business.
Are you sure? And I believe you, but these cases jump out. Yeah.
Know that I am sure. However, if something comes up, Mr. Jordan has my contact information and I will come right back.
Excellent. Thank you. Carlos Brandon. Oh, now we're into probation revocations. Is that a PD case or is, hey, how are you? I'm well. Let me get the petition, the warrant, and then you can let us know, Ms. Bumpus. Mr. Brandon's here. We'll bring him out. Do you need a chance to talk with the prosecutor first or? Yes. Okay. Mr. Jordan, you're handling that?
Yes, Your Honor.
Okay. And Mr. Brandon, it's allegedly a new offense. Okay. All right. How about Mr. Lewis?
We're ready, Judge.
Okay. And there are two Mr. Lewises. Kendrick Lewis, you're ready on.
Yes.
The other Mr. Lewis is Mr. Wrights, and we are waiting on him. And then Gregory Watson. That is a complicated one. you also?
Yes, Judge, I just need to speak with him before we move forward on that one.
Okay. He's got a lot of moving parts.
Yes, Judge.
All right. So why don't we take a break? I will take a break so you guys can meet with inmates, et cetera. We may have a plea. We may have 2 pleas, maybe 3. You'll talk with Ms. Bumpus. We'll see. That'll be the first of the revocations we handle when we pivot to that as to Mr. Brandon. And I'll come back out as soon as folks say, hey, we're ready to do whatever we're going to do. You guys are here for what case? Pardon me?
Maybe it's Bilson. I'm supposed to go on, came to court last Wednesday.
Oh, you're Mr. Spencer. Mr. Wright is your lawyer also. Got it. Okay, you're here. Good. What happened? You didn't get notice?
I got the notice, but she put the mail on her car and I ain't see it till later.
Oh, that could have cost you, my friend. Okay. Do we have the case number for Mr. Spencer?
I do.
Yes, Your Honor.
Number 2 on the March 15th calendar. It's 21 SC 179777.
All right. Let me just look this up, Mr. Spencer, to make sure I know what's next. And thank you for being here. I told Mr. Wright that you needed to show up in person because he said, nope, I got him. I got his info. It's all good. So this is on the trial calendar coming up as well. I don't remember what you had said about workout ability. At first I thought this was the one with the College Park video, but then I learned, because I was going over that calendar, it's actually a guy with 2 cases, and his less serious one is the one with the College Park body cam video. So it's annoying, but maybe not going to determine it. But that's not this case.
No, Your Honor, this is, I believe that it should be able to work out. I've extended a new offer to Attorney Wright as recent as yesterday. I don't know if he's had a chance to relay that to his client yet.
Okay.
But the state is ready, and I believe that Mr. Wright has had all discovery for quite some time.
He said that. That wasn't it was just us tracking Mr. Spencer down. Mr. Spencer, I've got an address for you on Baker's Ferry Road. Is that where you live, or is that where your niece lives? But she steals your mail.
No, she has some mail, but she grabbed my letter.
I got it. So she lives there too, and she just grabbed all of it, and lo and behold, there was your real important letter. Okay. All right. So you're going to be back here in early April for the trial calendar. Mr. Wright will be talking to you before then. Just stay in touch with him, and we'll be sending a notice, and it's going to go to that Baker's Ferry Road address. Okay. All right. You're good to go.
Judge, I missed the earlier vote, but can I be excused as well?
Yeah.
Thank you.
Sure. Mr. Jordan sits alone. All right. So I'll go back there, and then just let Ms. Nelson know when we're ready to do something. And I'll come back. Thanks.
Thank you.
Was Gregory Watson, was he brought over?
Yes.
Okay, perfect.
Wait, before you guys break, what are we doing, Mr. Torre, now that you are not tied up with Mr. Tutman? We'll find out.
Yes.
Okay, I'm gonna leave this posted here then, and we'll get an update. Thanks. Glad I saw it. Then I promise I'll go away. Oh, yeah, there's Mr. Spencer's stuff. Interesting. Of what? Today's calendar? No. Oh,
Need all the people that's in the back.
Okay.
I can write it down. You gonna write it over? I can just make a copy because half of them already been seen. I'm gonna make the copy. I'll advise that you will be.
Okay. Takes forever. I'm ready.
Anybody else need to come in today?
I will.
Is Mr. Young still back there?
Who you need first? Watson.
Hey, Julie, how are you?
Try to get to the back. I love the handcuffs. I would do stuff like this. I love paint. I want to get my car back. Really?
It's WI. Do you have a piece of paper? It's no problem. What's your name, sir? I can text you. Okay, yeah, I'll say
Y'all going out to Philly? Okay, you got some people want to see you? Okay, you got right maybe.
Today.
Yeah.
Lee might have pleas. I don't have any pleas today. I just have a revocation. But it-
Probation, are they gonna?
it's not gonna be a hearing. It'll be a stipulated revocation. And it won't be that long. She might have pleas. I don't know.
Just saw what I should say, I'm just going back.
But yeah, it's up to you. And of course you can always watch on YouTube
Yeah.
if you wanted to stream from the office.
Yeah.
Okay.
Should I wait to ask for the excuse or am I basically excusing?
You can stick around, but generally he knows if you got the waiver in, especially since we're still here.
Yeah.
So yeah.
It's okay. I
Mhm.
don't want to disrespect.
No, you're fine. And I'll let him know.
Okay.
Okay?
Thank you.
You're welcome. Thanks for coming down.
Okay, we good on that.
We're good.
No, you're fine. I'm just gonna bring him out. It's not gonna resolve today.
Okay.
He wants to talk to court.
Okay.
So,
I
but
got you.
Lewis,
Okay, great.
thank you.
Watson doesn't run his office. He's basically there, right? For every year.
Hey, man.
That's the one that just was. going
Yeah,
crazy.
yeah.
And then he's saying y'all, like y'all.
Yeah.
People are crazy, man.
I represented him, Julian, before you got in here, so I've had a history with
Yeah, okay, so you already knew what you were coming into.
It's funny. Deputy Kitchen, who did the security and alarm check? Who called it?
I called it, and okay. The day is Tuesday. 20 what? 21st.
I can be in my office by 11 o'clock.
You got this.
Tell me if that's already ready or not.
I think we definitely can.
Is today 3/21/23?
It is.
Okay, so that must be the. She must have sent me that for this case. Hey, Miss Nelson, how you doing? I'm okay, how are you? Where is she in? Why can I hear
She's
you?
on Zoom.
Oh, you on the Zoom? Oh, I just trying to tell you that. You from New Orleans?
Mm-hmm. Yeah, born and raised. Oh, you see my socks? Yeah. I always got to do something in New Orleans. What about you? Where are you from? You from here?
You put your phone on my right, Who's your supervisor?
Rashonda Davenport.
No point in me even trying to call.
It's always,
And that's all I can say.
Mm.
Interesting. Nothing bad, just.
I understand.
Just.
It's a tough job. Let me see. What's your boy's name again? Brian Marshall. Let me see. It's got to be on the upcoming court date or something.
That's probably him with all that. That's crazy how this stuff works, man. Man, barely, it probably ain't did nothing, to be honest.
So you got April 25th is the next court date, and he's on for the June 7th trial calendar. Mm.
Don't shortchange, yeah, roll the whole thing in there. Pardon me? I don't know what your staffing levels are. We only need Mr. Brandon. But if you're gonna have a defendant out here, if that means everyone has to come out, then everyone has to come out. So you're ready?
Yes, Judge.
Okay. Are you doing our, have I already talked to you about it?
No, you haven't talked to me personally.
Are you doing our C3 project?
Yes.
Well, then I don't have to talk to you about it because you're doing it. Thank you.
No problem.
Has it been a hassle or is it working all right?
It's the same as anything else.
How many cases do you have?
I only have 3.
Okay, I think that's about as much as we've done so far. We didn't want to overwhelm folks right away and have everyone quit, but I think we will do another round soon because we need it.
I wish I could get paid for, what's his name, who I volunteered on his team.
Well, this is how we're making it up for you. We pay better rates than any other county. While we're waiting on Mr. Brandon, Mr. Torre, we need to deal with now that we're not losing Ms. Feely to the Emerson calendar.
Yes, Your Honor.
So is that going to happen?
We will be ready to handle that matter. I believe it was originally scheduled for the 23rd. Is that correct?
I don't know what's next. He's coming. He's either be here in person or virtually. Hopefully in person because there's going to be an interpreter. Okay, as long as he's on our calendar, and we'll now have.
I got a shit to do.
And by then, Your Honor, we will absolutely be clear if it's going to be a dismissal or if we just.
I am not lobbying for a particular outcome. I'm lobbying for an outcome.
Yes.
And you good lawyers will sort that out. Hey, Mr. Brandon.
Hey, how you doing today, sir?
All right, let's make sure we are on the record. Oh, we got Mr. Wright. Mr. Wright, we will turn to you right after we finish this revocation, okay? I'll take that as an okay. Ms. Rivers, you.
Yes, sir.
Great. All right, Ms. Rivers, you ready to go?
Yes, I'm ready.
All right, position 13 is 17 SC 150181, State versus Carlos Brandon. Mr. Brandon is here in court with his lawyer, Ms. Bumpus. Mr. Jordan is here for the state. And I have a warrant that I signed in December of last year, so about 3 months ago, that alleges that in November of last year, Mr. Brandon committed a new offense of obstruction, maybe had some drugs on him, et cetera. And doesn't really say where that happened, just that it did happen. But we'll talk about it in a minute. What I'd like to learn first from, we don't have anyone from probation on the call. Ms.
I'm here, Judge. I just dialed in.
Oh, okay. You are 7618. Good. Ms. Bumpus is high.
7618, yes.
How are we going to do this? So, Ms. Tucson, how much time is left on Mr. Brandon's case?
He has 5 months and 30 days remaining.
All right, almost done. Ms. Bumpus, tell me what the status of these, is it the CP case that's on the calendar? These allegations have yielded the CP matter?
Yes, Judge. The CP case is the basis for the revocation.
Is the basis for the revocation. Okay, that's a much better way of saying it. All right. Is Mr. Brandon admitting to these or stipulating that he was arrested for this, or what's the plan for going forward?
Well, we had a plan, but 1 second, because probation just told us something we didn't know.
Okay.
Okay, judges, I will let the state make their announcements, but we're stipulating everything.
Okay.
And he only has 5 months and some change left. He's served almost 4 months.
Yep, I see that here. So let's turn to you, Mr. Jordan. What's the state's recommendation here?
Your Honor, the state's recommendation here, given the little amount of time that Mr. Brandon has on probation, is to revoke the balance community time served, Your Honor, given that Mr. Brandon, as Ms. Bumpus stated, has already served 4 months. Originally, the state's recommendation was going to be revoked 12 months, but given that he has such a short amount of time left, I believe that this is a fair negotiated resolution, Your Honor.
Do you have information different from Ms. Tucson? You had a reason to believe that Mr. Brandon had 12 months left?
Just bad math, Your Honor. I looked up the original plea, and I didn't calculate the years correctly. So given that Ms. Tucson's information, the state would our recommendation would be to revoke the balance commuted to time served.
So Mr. Brandon has a bond in the CP case, but it's a big old number. It's $72,000. Is that a bond he's made? And so this is holding him in, or that's a bond to which he aspires?
It's a bond that I believe he will be able to make, but I've advised him not to pay anything until this was
Right.
done because.
Okay. No, that makes perfect sense. I just wasn't sure. Sometimes in that conversation, I hear that's a fascinating number, but my client could never make it. And so it's effectively no bond. But you think, Mr. Brandon, you'll be able to make that bond?
I think that's his family told me yesterday.
Okay. All right. Will you be working with Mr. Brandon on the CP case?
Yes, I filed an entry on that case.
Okay.
We did that bond together.
Great. Oh yeah, look, there's your name on it. Okay. All right. I think I understand all that. Anything you want to add, Ms. Bumpus?
No, there's nothing I want to add.
Okay. Mr. Brandon, I find that you have violated the terms of your probation in the old case, the 17 SC case, by getting arrested for these new charges. And what the state wants to do is basically close out the old case. You're going to need to work through this new one anyway. I'm going to revoke 4 months. You'll get credit for the time that you've already served. If you haven't done quite 4 months, you may have a little bit more to do, but then I will suspend the balance of your probation so that once the right people determine the math that you've done 4 months, or they give you 2-for-1 credit, so they release you. The 17 SC case will effectively be closed out. You'll still have these pending charges. They're unindicted, but you'll be on bond, assuming you can make that bond that requires you to wear an ankle monitor paid for by the county, and says no driving. I don't know how that's going to play out, and you're going to have a curfew. That's it. Any questions about any of that, Mr. Brandon?
No, sir.
Okay. Ms. Bumpus, anything else on behalf of Mr. Brandon?
Oh, Your Honor.
Mr. Jordan?
Nothing further from the state, Your Honor.
So Ms. Tucson, I don't think we need to give Mr. Brandon any reporting instructions, because when he is done with his 4-month revocation, the balance will be suspended. Is that correct?
That's correct. There's no other cases he's on active probation for.
Done. All right. Thank you, Ms. Bumpus.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am.
Thank you very much.
Okay. Call me.
Thank you, Your Honor.
You're welcome. Mr. Wright. Yes.
Yes, Your Honor.
Good morning, sir.
Good morning, sir.
So let me give you the update that I got from Mr. Hiles, which was procedural only. And then we'll bring Mr. Lewis out once I've talked to you about this, just so we can work through this. He explained to me, and he was echoing what Ms. Nelson had shared from reviewing the transcript from Judge Richardson, was that Mr. Lewis pled to 2 cases in her courtroom. And you know all this because you represent the guy.
Yes.
Anyway, that plea was supposed to include a revocation that was effectively time served in this case from 2009, and then it reinstated the balance. The hiccup is that I guess everyone was so excited to be done with the plea colloquy that Judge Richardson never said at the end of the discussion, oh, and in 2009 SC, blah, 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 I revoke whatever time served would represent and reinstate the balance. There is no language to that effect, so there is no revocation order for anyone to sign. I've seen your email traffic where you're urging Mr. Hiles, man, just dismiss the petition. I didn't hear him say that's what he wanted to do today. I heard him say, I think what we ought to do is basically follow through on what everyone discussed in the plea colloquy with Judge Richardson. It just would be Judge McBurney who would say the magic words on the record in court with your client present and you here virtually, and then I'll sign a revocation order that is premised on the 2 new felony convictions and revokes him just for time served. Does that make, first of all, does that fit with your recollection of what was supposed to happen with Judge Richardson?
Yes, Judge. And bottom line, because this lingering is the only thing I think that is still keeping him. Once we fix this, and I think everything will be the way we intended it to be.
Okay. So I think that's half correct. I think it will be the way you intended it, i.e. what was negotiated in front of Judge Richardson and was really meant to be also this revocation that is coterminous with the custodial part of those 2 felony cases. There may be other things holding Mr. Lewis in custody. That was the part where I don't know that it's accurate to say there aren't other warrants on him right now, but it wouldn't be this. We would be liberating him from what has been holding him for a long time, which is the warrant on this 09 SC case.
Yes, Judge.
Okay. Then if you're all right with it, we'll bring Mr. Lewis out, and it's how do you say his first name?
DeAncius.
DeAncius Lewis, because we've got 2 Lewises back there. So if you could bring DeAncius Lewis out and sit him at defense counsel table, we will get that screen on too. Are you comfortable, Mr. Jordan, playing the role of Mr. Hiles?
Yes, Your Honor.
You've got some of the facial hair, but your mustache is better than his.
I've been trying to get to emulate his mustache, but it hasn't been working.
Yeah. I think you're doing fine.
Stay right here. Now come this way. Push up. There's your attention.
All right, let's go on the record in position 15. It is 09 SC 77853, State versus Lewis. Mr. Lewis is here. Mr. Lewis's lawyer, Mr. Wright, is in his home office, having been in another court earlier today. So he's appearing virtually. That's Mr. Wright. And something funny is happening on the screen there. And we've got Mr. Jordan here for the state. Mr. Lewis, I just spent a few minutes talking with Mr. Wright before we brought you out to make sure I understood where we were. You have a probation warrant that Judge Glanville signed in 2021 that alleged you violated your probation in this case from 2009 because of back then they were arrests. My understanding is not all that long ago, you were in front of Judge Richardson, and you and Mr. Wright entered guilty pleas in the cases that flowed from these arrests. And what was supposed to happen, it just people forgot to do the paperwork, is that you'd get sentenced in those cases with Judge Richardson, and then you'd get revoked in this case, the 2009 case, for the same amount of time that you served. And then they reinstate the balance. But Judge Richardson never ended up saying those magic words. And so what I was planning on doing today was saying those magic words so we could lift this warrant off you that Judge Glanville had signed. That was Mr. Wright's recollection of what happened in front of Judge Richardson, except just at the very end, she sentenced you in the 2 new cases. And she forgot to say, oh, and by the way, I revoke Mr. Lewis. Is that your recollection as well?
Yes.
Okay. Mr. Wright, tell me how you remember it being structured. I understand it's a time served situation. I just don't know. I think there's like a year plus left, and we'll find out from Ms. Tucson in a minute. But I don't know that it was revoking any more time because the plan was to keep a little bit of that probationary tail in place, unless Mr. Lewis was getting plenty of probation from Judge Richardson, and then I'm fine if there's not much time left on this case, saying, let's just revoke the balance, credit for time served, if he served that much time. Does that make sense?
Yes, Your Honor. And it was about a year or so of serve time associated with the pleas to the new cases. This case, it was always the intent to revoke, time served, reinstate. And then at the time, I don't even think we discussed how much was left. We now know that he only has a short period of time even left on this case. And because he's essentially, his understanding, at least from the jail, is that he was being kept because while he may have satisfied his time for the new cases, he was still showing this probation revocation as a reason that they were holding him, because nothing had been ordered on it. So it still looked like it was just an outstanding probation warrant. But now that he has essentially been in and we have such a short period of time, I think if we could almost either close this out or reinstate it and let it expire naturally in the very near term. And he will just have the probation left on the new cases, and the terms of that probation, don't violate the law. He won't be able to be around any gang members, stuff of that nature.
Right.
Will carry forward.
Okay. Do you have one of the case numbers from the Judge Richardson cases?
It is, bear with me. (22 SC 181359 and 360.
Okay. And Ms. Tucson, I've got that Mr. Lewis has 1 year and 22 days left on his probation in the 09 SC case. Can you confirm or improve that number?
On the 09 SC 77853, it is 1 month, 22 days.
1 month. Okay. So it really, Mr. Wright was saying it's just a trace amount of time, and it really is. Okay. I misread something that I got.
And there's 2 other cases that he's on probation for.
Those are the ones that Mr. Wright just shared with us, the 22 SC cases?
That's correct.
Okay. All right. And I'm looking at one of those right now, and it's 4 years of probation followed by 5 years suspended. So they extend far beyond what this probation would be. So what I will do in light of Mr. Lewis's 2 new convictions in 22 SC 181359 and 22 SC 181360 is revoke the balance of his probation, but reduce that to time served, and that will close out the 09 SC case. That will resolve this hold on Mr. Lewis. And so if he remains in custody at Rice Street, it's only because there are new or unrelated warrants. It won't be anything connected to the 09 SC case. Mr. Wright, does that comport enough with what you had negotiated with the state in front of Judge Richardson?
Yes, Judge.
Okay. Mr. Jordan, anything else for the state?
No, Your Honor.
All right. I'll let Mr. Hiles know you didn't mess it up for him.
And just to confirm that, if you could clarify, so because I didn't have those ones pulled up for revocation, I had the 09 SC 77853. So that way I could notify who has, Judge Richardson's courtroom as well. So for those other 2 cases, you're revoking those or all 3 of them?
No, ma'am. In fact, those 2 cases are the reason why I'm revoking this case. I'm not doing anything. Those just happened. Those dispositions were they were at the end of last year. And what should have happened in front of Judge Richardson was this revocation we're doing right now it was supposed to happen then. And they meant to, and then they forgot to say the magic words at the end so that your colleague completed the paperwork. So the only case for which I'm revoking probation is the 09 SC. And the basis for that revocation is those two new convictions from Judge Richardson's courtroom, the one ending in 359 and the one ending in 360.
Okay. And we are just suspending the balance.
However you want to work it, I intend for the case to, the 09 SC case to be closed out.
Okay.
All right?
All right, no problem. Thank
Great.
you for the clarification.
You bet. And I will sign that paperwork when it gets to me. And in the next couple of days, Mr. Lewis, that hold should be lifted. Anything else, Mr. Wright?
No, Your Honor.
Mr. Wright, Mr. Spencer showed up today, explained why he missed court, confirmed a good address, and I let him know that I would be seeing him soon because his case is on the April trial calendar. So no bench warrant for him. He was here and did what he needed to do.
Awesome. Thank you, Judge.
You bet.
Your Honor, he want to speak to his attorney.
Okay, that's complicated to do. You need to speak to him in private?
I just need to just tell him, could he come visit me?
Sure. That.
Would you be able to come visit me probably this week or next week? It's something very important I need to tell you.
I'll see you today or tomorrow.
Okay. Thank you, Mr. Wright.
Done. Thank you.
Have a blessed day.
You too. All right. Thanks, Mr. Wright.
Thank you very much, Judge.
Your Honor, Mr. Kennedy's here now. Do you mind if I run back to my office to get him that CD so I can?
Before we do, first, hello. Sorry about the mix up with your dad's email address. Should have named you something different. Not starting with the letter R. Fred Kennedy, then that wouldn't, but anyway, we'll try to get it with the M in it next time. Second, is there anything else ready to go?
Kendrick Lewis is ready, Judge. That's revocation.
Yep.
Gregory Watson, I don't believe will resolve today. He wants to address the court.
Okay. Mr. Watson last time didn't even come to the cell, so I'm glad we brought him over.
Yeah.
And then we've got a few other things that are percolating. So how, why don't we, so the one, I guess you've got two things ready to go. And you're getting discovery from Mr. Kennedy?
Yes, Your Honor.
Mr. Campbell's here. He may have been taken down already, but if not, is Mr. Campbell still up? Do you want to talk to him for a minute?
Sure.
Okay. Why don't you go talk with him while you, Mr. Jordan, going lightning fast, get the discovery for Mr. Kennedy.
Yes, sir.
And then just let one of the deputies know when that's done and I'll come right back out and we'll take care of the other Mr. Lewis and we'll hear from Mr. Watson.
Thank you.
Thank you, Judge.
All right.
Here, I might just find it from mine. Please, I'll sign in.
I'm about to give you at least has the reports on the jail calls and investigation. Thinking that we can get in for such a long time at this point.
I'm going to interrupt you guys for 1 second. I did tell your client that I put his case on this consolidated trial calendar where we're putting our very, very oldest jail cases. That is the second and third week in April. So he is now aware of that. I said, it may not be a trial. I'm not telling you you're going to trial. Your lawyer's working hard on your behalf to see if there's a fair negotiated resolution. But I don't want you to be surprised if he says, hey, trial in April. I put the case on there because of its age.
Okay.
And we'll see what happens.
Thank you.
All right.
Yeah. Okay. Can we do
It's gonna be a revocation.
Kendrick Lewis.
Oh,
Yeah.
if he wants to do
Yes,
that
the
today,
other
that'd be, it's a lot of police reports and everything, but if we can take that soon.
Let me talk to him.
Okay.
I don't want to speak for him.
I got you. Okay. Absolutely. Okay, that's great. All right, I'll be right back with the CD.
All right, who all need to go in the back? Talk to staff. Anybody else?
Take this with me.
And who do we, whatever the other one wanted to talk to me, probably David.
That's weird. Yeah. I got something from my group. Yeah, it's all work. You know? I don't think we're alone. I mean, we're cops. We can't get these thing out of wake up. Yeah. He's not going back out.
Thank you.
Just to see the status.
Good, how are you?
You got David, you want to copy him? David. You got somebody who wants to talk to you in the back?
I talked to him last week, but I'm happy to tell him the same thing I already told
Is
him.
it Davis?
Lewis?
Lewis.
Yes.
You already came back here and talked to him already?
No, I talked to him like in the bus with the jail, so there's just not an update, but I'm happy to talk to you.
You're welcome. Thank you.
Sure.
True. I didn't get it in this website. Yeah. Okay. Oh, okay. Okay. It's not taking a second because it's a big release report. But yeah, I'm fine. Yeah. No, that's why just in case I wanted to grab this just to be sure. Yeah, I'm fine. Yeah. Okay, cool. I'll let them know. I guess we'll. Okay, cool. Because it's been 4, right? There's a 5. 4. Okay. Okay.
Y'all ready on? Huh?
One more time, if you don't mind.
So long, if you need to. Oh, AP, you're supposed to stay on.
You gotta use my keys.
You have to do it.
I think we're ready on the two, you were ready on your two cases, Lacey?
Yes.
Okay.
Mhm.
And then we've got the Alexander. plea.
Okay. Okay, great. Okay.
Where do you guys keep the plea proceedings?
Normally they just ask for our permission to sign them, but I think we may have to move there, but I'm not sure if you might want to ask the PDs. Okay.
Do you have pleas or you have probation?
Probation.
You got the Alexander plea.
Next. Is it Joe? Dear Joe. You can just have a seat. So I probably just gonna do it. I have a look at it, but this is. Put one out on water.
Mr. Kennedy, did you get to speak with Mr. Campbell?
I did, Your Honor.
Great.
This case is gonna be a negotiated plea. Still need to have him fill out the Boykins, but
Oh, we're doing it today.
if you want to.
I do. All right. Huh. Fantastic. Take your time. I'm here all day. We'll do other things though right now. Ms. Wood, you were ready on Mr. Lewis. You want to start with that?
Yes, Judge.
Okay, so this is Kendrick Lewis.
Walk this way. Push up.
I don't have this warrant. I have Mr. Watson's 2 warrants. I don't have Mr. Lewis's warrant. Let me see if I can find it in Odyssey. Was not attached.
I can send it over if you'd like to Ms.
Okay,
Nelson.
that'd be great. I'll see if I can find it in
problem.
Odyssey while you are doing that. Warrants.
No problem.
That's right.
What's the date of the warrant?
December 6th, 2022.
Thank you. All right, I think I found it. There it is. Okay, Ms. Rivers, you ready?
Yes, I'm ready.
Okay, this is position 1419 SC 170816, State versus Kendrick Lewis. Mr. Lewis is here with his lawyer, Ms. Wood. We've got Mr. Jordan for the state, and we're here on a probation warrant that I signed in December of last year. And the allegations, there are 2 allegations, Mr. Lewis. One is that you didn't report. There were several reporting dates in, it looks like August and October of 2021, so a while ago. And then you had a couple arrests. I see 3, one in Irwin County, and you were sentenced on that. One in November of 22 in DeKalb, and then one in December of 22 in DeKalb. Those are the violations the alleged violations we'll be talking about, that you had some arrests, looks like mostly for misdemeanors, maybe not that last one in DeKalb. And then you also kind of disappeared from probation. They were trying to find you and you weren't showing up. Ms. Tucson, how much time remains on Mr. Kendrick's case?
1 year, 3 months, and 16 days.
And is this the only case for which he's on probation, or are there others in other jurisdictions?
Let me double check. This is the only one.
Ms. Wood, what is Mr. Lewis admitting to these arrests and that he failed to report?
Yes, Judge.
Okay, what's your recommendation as to what we ought to do?
We're asking the court to consider revoking 60 days, giving him credit for time served and reinstating the probation.
Okay, it looks like Mr. Lewis has already done 60 days.
Yes, Judge.
Mr. Lewis, do you have a place to stay when you get out?
Yes, sir.
The address that was on file with probation was an address on Venetian Drive.
That's my sister.
And are you able to stay there still?
Yes.
Okay. Does your sister know you may get out soon?
Yes.
And she'll let you stay with her?
Yes, sir.
Okay. What's going to be different this time? Other than I know you spent a little time in jail, but why should I think you'll report to probation and all that?
This time I'm reporting probation because I'm getting into sober living of America. I'm going to that program. I got a separate level to go there. And that's what I'm getting to once I get out of here.
And is that a program where you go live with them or you go to classes with them?
I go to classes and I move there too.
Okay, so you move from your sister's to the sober living location.
Yes.
Where is that?
It's in College Park.
How did you learn about this?
Right before I came to jail, I had got signed up for it, but I wanted to get this out the way so I won't get in the program, then have to backtrack and come here. So I want to get everything out the way first, then go to the program and I leave.
Clear everything up.
Yeah.
You're going to sober living because you struggle with alcohol or drugs, or what is it that you're trying to?
Alcohol and drugs, but then I try and get my job and everything, take care of my kids and my grandkids, sir.
Okay. How many kids do you have?
I got 8 kids and 4 grandchildren.
That's a large number.
Yes.
What kind of work can you do?
I can do warehousing, construction, detailing cars.
What's the last job you had?
Last job I working in a restaurant, Miss Q's restaurant in East Point.
Okay. And what did you do there?
Washed dishes and cleaned up.
How long were you there?
I'm there about 6 months.
Okay. All right. Mr. Jordan, what's the state's recommendation?
State's recommendation is to revoke 4 months, Your Honor.
Do we know, Ms. Wood, are any of the arrests, some of them are recent enough, it seems like there'll be charges pending in other jurisdictions? It sounds like Irwin County went away because they even list a sentence for that.
I think the DeKalb, you only got it on bond, correct?
Yes, 6 bond.
So DeKalb would still be pending.
Okay, but you're on bond. There wouldn't be holds for you.
No, sir.
Okay. All right. When does the sober living program start?
They told me call 2 days before I get out.
Okay.
I already got something that supposed to have been got mailed to my Miss Feely.
I have one, but it's not for you. I'm sorry, Mr. Lewis.
They say for me because they said I had Miss Patel at first.
Yep.
And then they sent it to Miss Patel, so then I had to tell them to send it to Miss Feely because I didn't know Miss Patel was not with y'all. I had to find that out too.
Okay, well, maybe they'll send another one. I'm impressed that you are trying to get involved with something like that. How old are you, Mr. Lewis?
I'm 38 years old, sir.
Okay. How young is your youngest kid?
He just turned 2-year-old November 7th.
How old? Your oldest kid hopefully is a little older than that if you've got
21.
grandkids.
He's 21.
21. Okay. Do any of the kids live at, did you say it's your sister's house at Venetian Drive?
Yeah, my sister.
Yeah. Do any of your kids live there?
They come over there.
Okay.
I got kids. My oldest daughters, they stay in Clayton County. And then I got my oldest son, he's in Conyers. Then my other set of twins, they in Atlanta, up in Atlanta.
Okay. And they're all these kids, either some of them are grown, but they're staying with their moms?
Yes, sir.
Okay.
I'm on time. I gotta get out here and take care of them, sir.
Okay. All right. Well, Mr. Lewis, I hope you're able to do that. What were you doing in Irwin County? What's your connection to Irwin County?
That was my last baby mother stayed down there.
Okay. Meaning the mother of the 2-year-old?
Yes, yes.
Okay. Where is Irwin County?
Ocilla, Georgia.
Where's that?
Down in my Tipton and Fitzgerald.
Okay. And you went down there, you met her down there, or you met her up here?
I met her up here. I just went down to see my baby.
Okay. All right. Well, Mr. Lewis, you are reaching an age where getting out of commission is going to be harder and harder because you're not there for your kids, and these different charges sort of catch up with you in the end. I am going to revoke 100 days of your probation. You will get credit for the time that you've been in, and I will reinstate the balance. There's not a ton of probation left, but enough that I want to reinstate it so that if you don't plug into this program, then we can have a conversation. I'm going to amend the conditions of your probation to require you to be enrolled in the sober living program within 3 weeks of being released.
Yes, sir.
I will also waive your supervision fees for the first 3 months after you get out. So you can get plugged into sober living, start working, all that. But it will be a condition of your probation, a special condition of your probation, that you participate in the sober living program for the remainder of your probation.
Yes, sir.
And I will ask that your probation be supervised for the remainder. There's only going to be about a year left.
Okay.
And so you'll need to do the sober living, and it will be supervised. And like I said, your probation supervision fees will be waived for the first 3 months. Ms. Tucson, do you need any other information?
No, Judge, Ms. Wood, she already sent me the information, so thank you very much, Ms. Wood. And just when he is released from custody, just make sure you report to probation, and all your, paperwork will be in, so they will be waiting for you.
Yeah, you need to, within 48 hours of getting out, go to probation. You know where that is?
That's downtown by the pretrial, next door to the pretrial right there.
Is that correct, Ms. Tucson?
It's a 276 Memorial Drive. I apologize. There's so many things down here. I'm not sure.
Okay.
But I know it's at 276 Memorial Drive. It's
Right.
not too far from the courthouse.
Right. It's about 2 blocks from here.
Yeah, I got
Okay.
it. All right.
Good. All right. If there's nothing else, you are good to go, Mr. Lewis.
There's the address. Thank you, Judge.
Mhm.
So there's the address if you need it. Just keep this with your stuff, okay?
All right.
All right.
I'll
Good
leave
luck to you,
today.
Mr. Lewis. No, not today. That depends on the sheriff. That's a copy.
He's got so constant distance for these which are counts 1, 2, and 5.
So we'll bring Mr. Watson out in a minute. But I need him in a minute. Mr. Watson's going to come stand in the doorway in a minute, Mr. Jordan.
Yeah.
He has 2 options. He can decide, I want to work this out, or he can say, I want an evidentiary hearing. I need to know what you'd be prepared to go forward on, not today, but at some point. There is an allegation that he committed armed robbery and crossed guard lines with weapon or drugs. That's one of the CP cases. So I want to chart a course forward for Mr. Watson so he knows what's next. He's been in for a while. He admittedly had 2 different CP cases, but one the state has dismissed. So the only one left is this armed robbery, where in looking at the warrant, he allegedly had a bottle in his hand and took $20 from someone. And so the next stop is to set this down for that evidentiary hearing.
Yes,
that's something that you are prepared in the sense you're willing to go forward with if that's the next thing we do.
Yes, Your Honor.
Okay.
That's correct.
All right. Ms. Tucson, before I bring Mr. Watson out, how much time is left on his 20 SC case?
1 second. I have his other paper right here. And for Mr. Watson, so the 20 SC 175614, he has 2 years, 4 months, 26 days remaining. And then he has another case. It's 22 SC 181362.
Yep.
2 years, 10 months, and 22 days.
Okay. So there's still some time left. Great. Do you want Mr. Watson to sit with you, or should he just be right there? Okay. All right. You don't need to take this down, Ms. Rivers.
Okay.
Hey, Mr. Watson, I'm Judge McBurney. How you doing? So I want to tell you a little bit about where we are, and then you can tell me where it is you want to go next, okay? So you've got two cases with me from 2020. I don't know if you pled with me or it was Judge Reeder, doesn't really matter. You're on probation for two cases. You got about 2 years and a few months of probation left on both those cases. I have signed warrants in both those for alleged probation violation. And the basis for that is that on the last day of May last year, it's alleged that you committed an armed robbery. And then I can't tell exactly what happened, but when you got booked in, you supposedly had something on you you shouldn't have. The more serious thing is the alleged armed robbery. These are all allegations. I read the warrant. The allegation is you had a bottle and threatened someone and maybe you got $20 from him, but we're not working through that today. What we need to figure out is what you want to do next. The state has made some recommendation, I assume, through Ms. Wood. She's relayed to you if you wanted to stipulate that, yep, I got arrested for this stuff. But you don't have to do that. You decide, you say, that's ridiculous. I'm not going to admit to it because they want too much time. I didn't do it. And that gets us to plan B, which is we need to have, it's kind of a mini trial. The state, the prosecutor's right there, Mr. Jordan, he'd have to prove that you violated probation. So they have to bring in a witness or witnesses. And I'd hear those witnesses. Your lawyer would have a chance to cross-examine the witnesses. It may be that you testify. You get on the stand and say, I wasn't even there, or I was there. He took my money. I didn't take his money. I don't know the facts. What I do know is we've gone around and around a bit. You've been sitting in jail for a while, and I want to move forward with this. So are you asking for hearing, as in evidence, state prove your case? Or what is it you were thinking we need to do?
How long is it gonna be until the state think about indictment?
I don't know about the indictment part. I don't control that. It could be a long time. It could be a little time. I know this. If you were interested after talking with Ms. Wood, like, you know what, I want to work out this new case. I don't want to wait any longer, and I'm willing to plead to X and Y and Z. I'm not saying you're willing to plead to anything or that you should plead to anything. Maybe you are. Then there's something called an accusation, and you may already know what that is, but then they don't have to get in front of a grand jury. And maybe it's an accusation to robbery rather than an armed robbery or theft by taking or who knows what. But the sense I was getting was that there wasn't a lot of discussion about how best to move forward. But bottom line is, I don't know when they'd indict you, and I don't control that. Can you talk to the state? You can talk to your lawyer and she'll talk to the state, but there's a reason that we put a lawyer in between you and the state, because the state might trick you into doing something. I'm not saying Mr. Jordan would do that, but things can happen when you don't have a lawyer by your side. You may get a little frustrated and then all of a sudden you've said something that sounds like you're threatening the prosecutor, and then that's new charges, and no one wants that for you. So I'm gonna work my way to my left. Ms. Wood.
Judge, Mr. Watson has asked about the potential of me.
Because I know for sure, I know I'm sitting like last time. Last time, I'm sitting like, what, 18 months until I gave y'all a conviction.
So
Okay,
Judge,
so it won't be 18 months from today. I promise you that. Let Ms. Wood finish. And I'll hear from you last. I'll let you have the final word. Ms. Wood.
my understanding is that he wanted to resolve this and the CP cases today, and unless Mr. Jordan can work some magic, I don't think that's possible today, and that was my advice to him.
So, but that's good to hear. So if Mr. Jordan is in a position to accuse the CP case in the next few days, we could get Mr. Watson back, not in months, but in weeks, in March or early April, to resolve everything, if that is the direction Mr. Watson wants to go.
Yes, Judge.
Okay. Mr. Jordan, you stood also. What did you want to add to the
I
mix?
have absolutely no issues with negotiating all the probation matter and the pending CP matter, whatever Ms. Wood gets from Mr. Watson. I would definitely do whatever I can to help this situation move forward.
So assume for a moment, Mr. Watson says, I'll waive indictment and I'll move forward on an accusation because then we can move faster. How does that process work these days? It evolves, but you would reach out to someone to say, I've got a defendant who is willing to move forward with an accusation. Do you draw up the accusation or you hope someone does, or what happened?
Be able to draw up the accusation, Your Honor, and just submit the waiver of indictment to Ms. Wood, and she would have herself and Mr. Watson sign it, and I could get that indicted by the end of the week, or accused.
Okay. So if we had the ability to get Mr. Watson here, we'll be in trial early next week, but either late next week or early April, that would give you enough time. What I don't want to do is bring Mr. Watson back and he comes out, Ms. Wood and he and I are looking at you and you're like, they haven't accused it yet. You think by early April, which is a week and a half, you could have it accused, assuming Mr. Watson wants to move forward that way.
Absolutely, Your Honor.
Okay. That's not 18 months. That's like 18 days, maybe less than that. Is that what you want to do? Or you want to talk with Ms. Wood some more?
If it's beneficial for me, I would love to do that. You want, because can I talk?
You can. Just don't talk about the facts of your case.
I know I'm gonna be sitting here. If I don't do that, I know I'm gonna be sitting here.
Okay.
Just know I'm gonna be sitting here. Like last time, I'm be sitting here.
People and people sit a lot out at the jail. I hear you. So you've got an opportunity here. It sounds like you're interested in it, to have the state drop that accusation. You and Ms. Wood will need to talk about what that means. This doesn't necessarily mean, I want to make sure I understand that it's not necessarily the case that Mr. Jordan's to come in here and say, and we recommend time served. He might recommend 2 years. I'm making that up, but he may say, I think Mr. Watson should serve 2 years because of what he's pleading guilty to. Now, Ms. Wood doesn't have to go along with that. She's going to say, dang, the guy's been in for almost a year now, 290 days, 300 days. We think it should be time served. And I'll listen to both sides and I'll tell you what I'm going to do.
I was only doing that to get a time served. That's either I would travel. I would sit here and go to trial.
So no one can guarantee you time served. I don't know enough about the situation to say that's what you'd get.
Maybe not time served, but look how long I've been in. I've been in almost 365 days.
Yep. So why don't we do this? Why don't you draft up the waiver of indictment form and the proposed accusation so that Ms. Wood can see it? Because if the proposed accusation is murder and treason and all that, he shouldn't go forward with that. But if it's consistent with your understanding of the CP case, then Ms. Wood can connect with Mr. Watson to say this is what it would look like. Understanding that there's no guarantee that it's a time served, but there's a difference between you sitting around waiting forever and having a chance to work it out. Maybe they can line up a program for you. It's a great question. So let's do it that way. And we'll bring Mr. Watson back as soon as Ms. Wood hears from Mr. Watson. Yep, I'm all right with this paperwork. Okay?
Yes, sir.
All right. Mr. Watson, I appreciate you sharing your concerns with me. I hear you loud and clear about your frustration with how long you've been sitting around. We'll see you soon, assuming you want to go forward with the papers you described, okay?
Thank you, Judge.
Thank you, Ms. Wood.
I have no further business. May I be excused?
You may.
Thank you.
So what we'll do so we don't lose track of Mr. Watson is get it on an inquiry calendar, maybe a month out, but if stuff gets put together before then, super.
Thank you, Judge.
Thank you.
All right, Ms. Feely, you are back in the driver's seat. Let me go back from the beginning of the calendar. So we had Mr. Alexander as a possible 3 pleas and a NPGJ. Is that going forward?
It is.
Okay. Whoops, let me cross him off. What about Mr. Lawrence Jones?
I spoke with Mr. Jones and that will not be a plea today.
Okay, so we should do his status conference. What about John Davis?
Same with John Davis. I relayed his offer and he's not interested at this time.
Okay, so we'll get all that on the record and then we'll take Mr. Alexander's pleas. And then if we need to break a little bit so Mr. Kennedy can get with Mr. Campbell to finalize that, we'll do that and we can take Mr. Campbell's plea.
Thank you, Judge.
Excellent. Okay, so let's please bring out Lawrence Jones.
Do you want Mr. Jones? Have a seat in this chair. Push yourself up.
All right, let's go on the record in position 9. It's 22 SC 184065, State versus Lawrence Jones. Mr. Jones is here in court with his lawyer, Ms. Feely. We've got Mr. Jordan for the state. Mr. Jones, we're going to talk about your case for a little bit and figure out how best to move it forward. Ms. Feely, do you have the discovery in Mr. Jones's case?
I do, Your Honor, and I believe I have everything. I've spoken with Mr. Jones. I need to do so in more detail at the jail. But we are not interested in the state's offer. I do think this could move to a trial calendar.
Okay, I'm going to get that offer on the record in just a moment, but you are comfortable. We're on the May trial calendar. So if we go forward with Mr. Jones's trial in early May, you're good with discovery.
Yes, Your Honor.
Got it. Mr. Jordan, what is the offer? If Mr. Jones were to enter a plea today, what would the state be recommending?
This was actually ADA Willingham's case, Your Honor, but I do believe if Ms. Feely can give the communicated offer as Ms. Willingham was released.
Okay.
My understanding of the state's offer was a 10 to serve 2.
All right. So assuming that's accurate, you understand, Mr. Jones, that if you were to enter a plea today, you would have the right to withdraw your plea if you did not like the sentence you got. So it sounds like the prosecutor, who's not the gentleman standing up, someone who was here earlier today, she would be recommending that I sentence you to 2 years to serve, followed by 8 years on probation. Ms. Feely would be free to recommend something different. She might say, time served, you've been in for over a year. If I sentenced you more severely than what your lawyer asked for, you could back out of the plea today. You could say, you know what? I want to take that back because I was willing to do this to get time served, but I'm not willing to do it for another day in jail. After today, you can still enter a plea. You may decide, I don't want to go to trial. The jury's going to clobber me when they see the video or whatever. I don't know what the evidence is in your case. You can still enter a plea. The only difference is if you do not like the sentence you get, you don't get a back out of it. You understand that? And if not, you want me to explain it differently. You got it? And you just say out loud so the court reporter can take it down.
Sorry, I gave him something to read right as the court asked him a question.
Okay.
If you wouldn't mind answering the judge's question first.
You understand that today you can withdraw your plea if you don't like your sentence, but after today, you do not get to withdraw your plea. You understand that? You say yes or no out loud.
Sorry, yes.
Okay. The sir part I don't care about, just the yes, because the court reporter needs to be able to write it down. All right. So trial ready case, you've got discovery. It'll be on our May 8th trial calendar and we'll handle it then. Anything else?
I need to tell him one thing that has transpired since I spoke with him back, if I may.
Okay. And it looks like he's got a question. Why don't you tell him first and then I'm happy to hear your question.
He was here. So I talked to him and I've already sent him an email. And he's gonna get me in touch with who I need to be in touch with. Like he was here, you were right. He was just in the hallway, but I found him.
Let's see if I can get, I got 3 charges that I was indicted on with no bond. I want to see if I can get them all consolidated as one bond, as like my bond is 15,000 right now for the original charge.
Right. Your case falls into this pattern I was talking about with some other lawyers this morning, where it shows you've got a bond and then you've been in jail for a long time. In fact, I can't tell how many days you've been in. The calendar says one thing and
14 months.
Odyssey says another.
Days.
All right. That sounds like you're counting. Here's what we'll do about bond. I'm not interested in revisiting bond until we get to this trial calendar. If we do not reach your case on the trial calendar, then I'll ask Ms. Feely to file a motion for bond, and we'll have a bond hearing after the trial calendar to see if, I doubt, but I don't know, I'll need to hear about it. I doubt I'd say spread that 15 across all the counts. It would be more likely that I would set a bond rather than there being no bond for all the counts. Okay. Mr. Jordan, anything else on behalf of the state?
No, Your Honor. I believe ADA Willingham said that they would be ready, the state would be ready for the May trial.
That's a good answer, given how long Mr. Jones has been in.
Yes,
all right. Mr. Jones, I will see you in early May. We're ready for John Davis next, please. While we're waiting on John Davis, oh, we already talked about it. Never mind. I'm really focused on Mr. Torre, but we got that on the 23rd. I get that off my line of sight.
Push up.
Okay.
We're just letting them pick up. We just have to put it on the record.
What about my bond?
Not today, but oh, we said major.
All right, let's get on the record with position 11, State versus John Davis, 22 SC 183787. Mr. Davis is in court with his lawyer, Ms. Feely. Mr. Jordan, is this your case or are you subbing for Ms. Willingham again?
This is my case.
All right, excellent. Mr. Davis, we're going to talk about discovery in your case, the evidence, and how a plea will work today versus after today. You are scheduled to be on our May trial calendar, so there's not a lot of time between now and then. I just wanted to cover all that with you. Ms. Feely, do you have all the discovery that you suspect is out there in Mr. Davis's case?
I believe so.
Okay. Mr. Jordan, what is the state's offer if Mr. Davis wanted to enter a plea today?
State's offer is 15 to serve 10, Your Honor.
Okay. Mr. Davis, if you were to enter a plea today, Mr. Jordan would recommend that I sentence you to 10 years in custody, followed by 5 years on probation. It's a lot of time. Ms. Feely would probably argue for something less. If I were to take a plea today and I sentenced you to any more time than Ms. Feely asked for, so I'm gonna make this up. Let's say she said, no, it should be 5 years to serve. And I heard more about the case and about you. And like, you know what? 5 is too low, 10 is too high. I'm going to sentence Mr. Davis to 7 years to serve. 7 is more than 5. And today you could withdraw your plea. You say, I was willing to take what my lawyer asked for, but not any more time. Do you understand that today you could withdraw your plea if I sentence you more harshly than your lawyer asked for?
Yes, sir.
After today, you are still free to enter a guilty plea. You could do it tomorrow. You could do it on the eve of trial when we bring you in here and say, hey, we're bringing in a jury tomorrow. You could still enter a guilty plea then. What'll change is your ability to withdraw your plea. You will not be able to withdraw your plea if you don't like the sentence that I give you. Understand?
Yes, sir.
Okay. Understanding all that, are you interested in moving forward knowing what the state's offer is today, moving forward with a plea, or would you like to have your case on the trial calendar?
I move forward with the trial if the plea is not lesser than what you offer.
Okay. So you know what the state's going to recommend today. They may change over time. They may talk to more witnesses and say, now we're offering 20 years to serve, or dang, let's reduce it to a misdemeanor and give them time served. Things change. But today it's 15 to do 10. That's what they're going to recommend. And you're saying you're not interested in pursuing that. You'd rather go to trial. Yes?
Yes, sir.
Okay. Then we will keep you on that May trial calendar. I will see you when we call the calendar, which will be in early May, and we'll figure out when we can try your case.
And Your Honor, he, similarly to the last person, is interested in a bond. I did file a bond motion back in November. But
I see that.
Trying to explain that he may be in the same boat after the May trial calendar if he's not reached.
Right. Mr. Davis, if we do not resolve your case on the May trial calendar, then we'll talk about bond again. I don't know if you're in a no bond status or if it's just a bond you can't make, but regardless, you've been in jail for a long time.
A year.
Okay. So if we don't reach your case on the trial calendar, or if you don't enter a plea, then very soon after that, I'll bring you back here for a bond hearing.
What plea did you?
Mr. Jordan, anything else from the state?
No, Your Honor, I did. I just wanted to say that for Ms. Feely, I sent an evidence.com link. I'm not sure if the medical records were included in there. I know she was preparing for trial up until recently. So when you get a chance, if you could just look through it, because I may need to send the medical records separately. I'm not sure if it was included in the evidence.com bunch or not.
You're not sure because someone else creates that link?
It's often it is all of the evidence is grouped together, and sometimes they'll have different evidence that's located on Odyssey. I sent the link with assuming that the medical records have been included within the evidence.com link, but I didn't check to make sure.
Okay. All right. So just put that on your radar, Ms. Feely, that the medical records are there, as in the state has them and is ready to provide them. There may just have been a hiccup with the evidence.com. All right. Do you need more time with Mr. Davis, or can he go? Okay, great. We'll see Mr. Davis in early May. Thank you. Are you ready for Mr. Alexander? Great. That'll be next.
And Your Honor, before we begin, Mr. Alexander, Ms. Feely sent me a part of the statute for the theft by shoplifting, the felony variation. And at the end of it, I apologize because I just had it up and then took it down. It does say, even though it is a year mandatory, that if both the prosecutor and the defense agree for it to be less than a year, then the court may sentence for less than the mandatory year. And Your Honor, I will go into this in the plea as well. The main concern of the state here is getting Mr. Alexander into housing, and he may lose the bed. He's almost at a year now. I believe he's at about 307 days. And I'm not sure if he would be able to still get into the bed if
at the program that's been identified for him. Okay. What is the statutory provision before we get on the record, just so I can be looking at it? I'm at 16.8.14. Is there a subsection there, or it's in Title 17?
C2, subsection big C, and then
Little Roman 2?
right.
Huh. That's new.
Thank Lauren Shubo for that citation or pointing out that portion of it.
That's great. Judges always appreciate discretion. All right. Well, let's turn to pleas then. Let's get all the case numbers in the mix first. So before we get on the record, I've got a case ending in 429 and 175. Oh, and then there's 196. That's the one that got out ahead of these. And then there's a CP case that, other than you announcing on the record in a little bit that it's being NPGJ'd or dismissed or whatnot, that's all we're doing with that one?
That's correct.
Okay, all right.
Should we be at the podium?
As long as Ms. Rivers can hear Mr. Alexander, I leave it up to you two where you're going to be. But make sure the microphone is on and in his direction.
Stay here.
We good? Okay, let's get on the record then. We've got Mr. Alexander, spelled Alexandre, in court. He has 3 indicted cases, 1 unindicted case. We're proceeding on the 3 indicted cases, 22 SC 182429, 22 SC 183196, and 22 SC 184175. And for brevity's sake, let's just refer to those indictments by their last 3 digits while we're working through it. There's also 22 CP 209163, an unindicted, also a shoplifting?
Yes, Your Honor.
Okay, and I'll let you address that on the record. Mr. Alexander is in court with his lawyer, Ms. Feely. Mr. Jordan is representing the state. Mr. Alexander, I'm Judge McBurney. How you doing today?
I'm doing fine, sir.
Good. I need you. You spoke up well. That's good. Keep doing that because we have a court reporter who is connected to us virtually, and she needs to be able to hear you while you're talking. Put you on spotlight there so she can see you. In a moment, Mr. Alexander, Mr. Jordan's going to put you under oath. I know you've done a plea before because I looked at your charging documents, and these are not your first shoplifting.
Yeah.
It's going to work the same way. You'll be under oath. Once you're under oath, please answer his questions and mine truthfully and completely.
Yes, sir.
It is very important that if you have any questions because you didn't hear what was said, or it's not making sense, or it's going differently than you thought it was, you let Ms. Feely know about that question so you all can talk about it, or we can talk about it as a group.
Yes, sir.
You are not required to wear the mask while you're in court. You're welcome to keep it on. That's a personal health decision as long as we can hear what you're saying. Okay.
Yes, sir.
All right, Mr. Jordan.
Yes, Your Honor. Mr. Alexander, can you please raise your right hand? Swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Stevenson, spelled Stevenson. Last name Alexandre, Alexandre.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Sir, no, sir.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
48. The highest I went was 11th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the following offenses in each indictment, starting with indictment ending in 429, theft by shoplifting, and indictment ending in 175, theft by shoplifting, and indictment ending in 196, 2 counts of theft by shoplifting, and 1 count of possession of drug-related objects?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Ms. Lee Feely, about all of the facts and circumstances known to you regarding the charges in these indictments, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Feely, do you waive formal reading of these indictments?
We do.
Do you also waive any and all defects in these indictments?
Yes.
Mr. Alexandre, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Feely, do you know of any outstanding warrants related to these charges?
I do not.
Mr. Alexandre, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
Yes.
And Your Honor, just for the record, for theft by shoplifting, the minimum is 1 year and the maximum is 10 years, since these are all felonies. And for the possession of drug-related objects, the minimum is 1 day and the maximum is 12 months in custody. Mr. Alexandre, do you understand that this is a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Your Honor, this is a global resolution. The state's recommendation for indictments ending in 429, 175, and 196 is 10 years to serve 1, commuted to time served. Mr. Alexandre has been in custody at least almost 310 days up until this point, Your Honor. The special conditions of probation, I believe that all of these cases involve Walmarts. So the special condition would be that he not return to any of the Walmarts. To my knowledge, he has been accepted to Sober Living America. So we did want to make his attendance of Sober Living America a special condition of probation. Also, and I sent this to Ms. Feely as well, but I'm not sure if Sober Living America does this, but a substance abuse evaluation and that he follow recommended treatment.
Okay.
And also as part of this global resolution, Your Honor, the state will be, we have already submitted paperwork, but it has not been filed as of this plea for a decline of his pending CP matter.
Okay.
Mr. Alexander, was that the negotiated resolution to all 3 cases and the pending unindicted case? Was that the recommendation that was communicated to you?
Yes, but my lawyer's gonna explain to the judge, because it was something else that I wanted done.
He wanted me to ask, and I don't think we had a chance to discuss this, if we could suspend or shorten the 10-year probated period with successful completion of the Sober Living America program.
Okay,
So
we'll cover that when I'll hear from you fully, but you can talk about that, and then I'll want to talk with Mr. Alexandre about that program and his plans.
Yes.
Mr. Alexander, do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Say that one more time.
Do you understand that first, that the court does not have to accept that recommendation?
Okay, yeah.
And do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you currently on probation or parole?
No.
Do you understand that since you were being placed on probation, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yeah.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and finally, your ability to obtain employment?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Mr. Alexander, how do you plead to the charges of theft by shoplifting, which would be in all indictments, indictment ending in 429, 175, and 196, and also the offense of possession of drug-related objects in indictment number ending in 196?
Guilty.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand for the felonies that you're pleading to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And for the one misdemeanor that you are pleading to, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, just for clarification purposes, the state's global recommendation, including the one misdemeanor count, was that for that count to be 12 months to serve, since he has served essentially 12 months commuted to time served, and all cases are to run concurrent with each other, Your Honor.
Okay.
For a factual basis, and my apologies, Your Honor, I left off the part. Ms. Feely, have you advised to Mr. Alexander his deadlines for filing a direct appeal?
We have talked about that.
And Your Honor, for a factual basis, beginning with indictment number ending in 429, that is a theft by shoplifting that occurred on April 7th. On April 7th of 2020, an officer from the Atlanta Police Department issued a copy of charges to Mr. Stevenson Alexander while working an approved extra job at Walmart located at 835 Martin Luther King Jr. Drive. While working at the location, the officer was advised by loss prevention that there was a male shoplifting inside of the location. Mr. Stevenson was observed leaving the location with a bag of laundry detergent and a bag of steaks. Mr. Stevenson was asked for a receipt at the exit door for the items, and Mr. Stevenson advised that he did not have a receipt. Mr. Stevenson was then taken to the Asset Protection Office, where all of the merchandise was recovered. Mr. Stevenson did advise that he did not purchase those items. At that time, he was issued a copy of his charges and released from the store. My apologies, Your Honor. If you'll give me 1 second, I thought that I had all of the police reports pulled up. I do apologize. For the indictment ending in 196, this was on May 18th of 2022. An officer from the Atlanta Police Department was working an approved job at the 835 Martin Luther King Jr. Drive Northwest Walmart. The asset protection did advise that a person later identified as Mr. Stevenson Alexander was seen concealing items on his person, then proceeded to pass all points of sale. The asset protection team detained Mr. Alexander and brought him into the office. Mr. Alexander admitted to shoplifting the items and was charged with theft by shoplifting and then was placed into custody. Also, during Mr. Stevenson's detainment, a crack pipe in a silver pusher was found in his right rear pants pocket. He did also have an active warrant at that time. It was discovered at that time that Mr. Alexander did have multiple convictions for theft by shoplifting, one case coming in 2002, or multiple cases in 2002, a misdemeanor conviction out of Clayton County, and also 3 convictions out of Fulton County. It was totaled that he had 11 misdemeanor theft by shoplifting convictions. And for the very last case, Your Honor, which was the indictment ending in 175, this occurred on February 12th of 2020 at the very same Walmart location. It was alleged that he took over $109 in items from a Walmart and did not pay for those items. And that concludes a factual basis, Your Honor, for these 3 cases. Attorney Feely and I have worked diligently to come to a negotiated resolution here, Your Honor. We do understand that Mr. Alexander has somewhere in the double digits of convictions for theft by shoplifting. The state is hopeful that Sober Living America will be able to help Mr. Alexander. The reason why the state is asking for such a long time as far as probation goes is just to keep him monitored. These theft by shoplifting convictions are sprinkled throughout the last 2 decades. So we definitely want to make sure that Mr. Alexander has all the help that he needs, but also that we don't lose track of him so that he falls back into the habits that he's had according to his criminal history. And we just ask that you accept the negotiated resolution.
Okay, thank you. Appreciate that. Ms. Jackson, good morning. We got a couple minutes left of morning. We're getting you in before the afternoon starts. How are you today?
I'm great. How are you, Your Honor?
I'm good. Thanks for sticking with us. How many cycles does Mr. Alexandre have?
72 cycles.
Okay. And the repeat offender notice that I saw that got at least one of these cases kicked to us listed 8 felony convictions. The most recent being in 2017 in Fulton and DeKalb. Do you have a similar count of felony convictions, or is it a higher number?
For his felony convictions, Your Honor?
Yes, ma'am.
Similar.
Okay. And then it sounds like there are a whole bunch of misdemeanors. I won't get you to document those. I also know Mr. Alexandre has been in jail for the last 300 days. So hopefully there are no cycles from late 22 or early 23.
No, the last one from the misdemeanor is in 2019. That was out of Cobb County.
Okay. All right. Thank you for that. Ms. Tucson, is Mr. Alexandre on probation on any of these cases, active probation?
No, Judge, he is not on active probation at the time.
All right. Thank you so much.
No problem.
So, Ms. Feely, in some ways, Mr. Alexandre is a prime candidate for a program. In others, he's a good candidate for a program after he's been out of commission for a while, since we're on cycle 72 and convictions 9, 10, and 11, whatever we're going to get at here. Tell me what you know about the program, why we're not looking at drug court and things like that.
So I was looking back, he actually was in, it looks like Fulton County Drug Court, and unfortunately, I think a lot of those cycles were sanctions where he wasn't formally charged, but was fingerprinted, I'm assuming, and booked in. But I do have his letter from Sober Living America confirmed that he does have a bed space there. As the court heard, these are all thefts from Walmart. None of them even were the felony amount. It simply is his record is the reason he's before you.
Sure.
So he's not violent. He's not running around with guns, nothing like that. This is just very low level criminal behavior, but just very much
Repetitive.
Exactly.
Right.
But he's 48 years old. He included in the 72 cycles, I would imagine from looking through Odyssey, a lot of those are violations of probation and drug court sanctions. So that's one of the reasons we wanted to encourage the court to not give him 10 years probation for the reason that, as we know, it fuels the mass incarceration, sets him up for just an extended time to get continuously punished for minor possible infractions. And we also wanted to propose to the court suspending part of his probation once he successfully completes this program, because I think it goes without saying that he needs to be able to get on his feet when he gets out, and he has been in almost a year. And I think this program will allow him to not just get out and go do whatever he gets himself into, but instead have some structure, and the housing piece is huge. So we are asking the court to substantially follow the state's recommendation, just with if we would consider a lower probation.
Okay. Would Mr. Alexandre be released to the program, or he'd be released and then we just hope he shows up to the program?
If we could give him like a window of time, he is going to have to get himself there. It's my understanding from talking with them, but he needs to do that right away.
If there is a bed available, is there a reason why we couldn't do a transport? I don't know where sober living is. If it's in Texas, that's not an appropriate transport order, but we do transport orders all the time where the sheriff's office delivers an inmate upon release to something within a reasonable radius. That's a reasonable radius.
Yeah, I spoke to her and she said, and she gave me the directions. And
Sure.
She expects me to come there.
Okay. So they are expecting him, but if it probably would actually make it easier for Mr. Alexandre if we transported him.
Sure would. Is there someone I can contact at Sober Living to talk about how long the bed is available, or what do you know on that front?
So my understanding is that the bed is available, but I do have contact information for Tammy Lewis, who's director of admissions. It's a phone number, and I believe I've emailed with her as well.
All right. What's her phone number?
Direct line is 404-537-1386.
1386. Okay.
And I can prepare a transport order.
Great. Mr. Alexandre, tell me why you think this time is different. I'm sure you've given this speech before, but I haven't heard it.
Yeah, it's like this. You know, I used to say a long time ago, you know, I'm sick and tired of being sick and tired, but you know, at the age I am right now, I'm looking at enough is enough, you know, and it's like, I'm knocking on 50 next year. And it's like, you know, it's just like this time that I just did right now, being drugged for 10 months over something that I did that was so petty and stupid.
What's the longest you've been in? What's the longest period you've been in jail?
In jail?
Yeah.
I say, for this type of charge, I did go to prison before for it. So it was like about 2 years.
How long ago was that?
This is a long time ago.
Okay. And you actually went to the Department of Corrections, or you stayed in a local jail?
No, I went to Department of Corrections.
Okay.
Yeah.
For shoplifting?
Yeah, for shoplifting. That was back in 03. Long time ago, back in 03.
Okay.
I was pretty much, a lot younger than that back then, but now I'm just, I've got arthritis now. I got heart problems. I ain't got, I ain't got the energy no more. So,
What is the addiction struggle you have? Is it alcohol or drugs or what is it that's behind all this?
to keep it 100, it's crack cocaine. It's crack.
Still.
Alcohol too.
Okay.
That got to play a part too.
And does sober living address drug use as well as alcohol use?
They do. Yes, they do. Yeah, they do. Yeah, they address narcotics, alcohol, and actually that's that. And another thing too that I'm tired of in my life, during my trial and tribulation with this lifestyle is me being homeless, not by force, by choice, really. You know what I'm saying? Like I can go home anytime, but really I can't go there that way. Not with that type of condition.
Where's home?
Home is Southwest Atlanta, where my mother's at right now. And I can't, I'm trying to have her in a better place by me changing my lifestyle right now. So, and then there's some things I need to do for her out there with another house that she got. And I can't, I really need to be more stable minded and more focused on myself before I even try to, continue to move forward, trying to help her do the right thing.
Mr. Jordan, it doesn't sound like there's any restitution because each time Mr. Alexandre was caught at the mouth of the store.
That's correct.
Mm-hmm. And their items going right back to them.
Yep.
It's going right back to them.
I don't know what all they put back on the shelves. It sounds like you had some steaks one time. They may not put the steaks
crab
back.
Legs, and name it. I had them all. So.
Okay. Mr. Alexandre, I find there is a factual basis for all three of your pleas. They're pretty simple cases. And while I agree with Ms. Feely, they aren't crimes that are hurting people in the sense of you're not shooting someone or stabbing someone. They're still crimes. It's still disruptive to Walmart's business. It makes everyone else's prices go up because of what you get involved with. And there are consequences, as you've experienced, because you've been in for 307 days.
Yeah.
Those consequences will only grow as you age. And it's sort of in the wrong direction. It's really when you were young that going away for a little while might have helped you think about it differently. Now you've spent almost a year as you went from 47 to 48. And that's harder and harder on the body.
Yeah, real harder.
I also find that your pleas are knowing and voluntary. Voluntary means no one's forcing you to enter these pleas, but you've decided that's how you want to move forward. Is that correct?
Yes, sir.
Knowing means you've understood all the things we talked about. And if you didn't, you asked Ms. Feely or me and we answered your questions. Do you have any questions at this point?
Yeah, I just want to really be clear to my understanding about what's going on with this plea, right? Is it 5-1 or 10-1 right now?
I haven't told you yet.
Okay. Oh, no,
So
okay, all right.
that's all right. And you should ask after I tell you the sentence, like, wait a minute, what's going on here?
Yeah.
I want to know if you had any questions about your rights as a defendant, to have a lawyer, go to trial. You understood all those things?
I understood all that.
Okay.
I understood all that.
All right. Mr. Alexandre, I'm sentencing you under the Probation Options Management Act, which means that while you are on probation, we haven't talked about how long that'll be.
Yeah.
While you're on probation, if you have a small or a technical violation, you and probation will work through that. You don't come back and see me. But if you leave the program early, you quit the program, you get arrested again, those kinds of things, come back to me.
Okay.
And we will work through what the consequences will be. I'll let you know now, the consequences will be, especially if it's another shoplifting, will be you get revoked for a while. You'll probably see Department of Corrections again.
Yeah.
Do you authorize my staff, Mr. Alexandre, to sign the 3 indictments or accusations, whatever they are, indicating your guilty pleas?
Yeah.
Ms. Feely?
Yes.
Mr. Jordan?
Yes, Your Honor.
All right. So I am going to sentence you on each of the shopliftings to a term of 10 years, 8 years to serve 1 year. So let me get them right. In 22 SC 182429, your sentence is 8 years to serve 1 year. You'll get credit for time served. It will be a special condition of your probation in that case. Number one, that you stay away from all Walmarts. This is not a place you get to shop, whether you're paying or not, to go somewhere else. You will need to enter into and complete the Sober Living America residential program. And you will be subject to random drug and alcohol screens for the first 2 years of your probation. In 22 SC 184175, same sentence, same condition, same sentence. That'll run concurrently with the one ending in 429. And finally, in 22 SC 183196, as to the, let me get to that one, shoplifting count, and there are 2 of them, counts 1 and 2. Your sentence is 8 years to serve 1, balanced, probated, same conditions. And then count 3, which is the misdemeanor, is 6 months to serve. Those counts all run concurrently with each other and concurrently with the other 2 sentences. So to answer your question, it is 7 years of probation. I will set a behavioral incentive date of May 1, 2025, which is 2 years and about a month. If on that date you have done well with probation, they ought to come to me to say, let's close this out.
Okay.
If you have not done well with probation, they're going to come to me to say, let's extend this out. So you control how long the probation will be. I am asking probation to provide me with a report 30, 60, and 90 days out. So 3 reports from probation after you're released, 30, 60, and 90 days out, confirming that you are in sober living, participating in it, and haven't absconded. Those can be written reports. The officer doesn't need to come to me, but 30, 60, and 90 days out, confirmation that you are still at Sober Living America. I will sign a transport order that gets Mr. Alexandre to Sober Living once they tell you they're ready for him. That will truncate his sentence. It will ultimately likely be less than 365 days, but I don't want to set it to 10 months or reduce the time served because there's a gap between today and when he can get to Sober Living America. But as soon as you lock in the date, Ms. Feely, with Ms. Lewis, then you know the routine, the transport order, get it to me in advance. It'll say transport Mr. Alexandre to, it's a one-way transport, et cetera. And that will take care of it. Yes, sir, your question.
So if my time not, I mean, like, is it commuted?
No.
So it's not commuted?
No, it's not. It is a year to serve. If for some reason Sober Living America doesn't have a bed for you before the year is up, I want to be clear, you get credit for time served. It's not a year from today. You've already done a big chunk of the year. But what I'm not comfortable doing is saying, let's let them out now and let's hope Sober Living has a bed and that you show up. You will go from the jail to Sober Living. You get dropped off there and you'll start the program. And then I'll get these reports at 30, 60, 90. So as soon as a bed is ready, I'll sign an order and you'll go there. It won't be that you have to wait for the year to run out. But just in case Sober Living says, oh my gosh, we're full, your sentence is a year.
I understand that, but I just, like, they got a bed ready. Like, I just spoke to her.
Great.
Like,
Then once I get a transport order, then you're on your way. But I don't have a transport order and I'm not letting you out without one. So it's basically you're going in a tunnel from the jail to Sober Living. The tunnel is called a sheriff's transport van. Okay? I'm not letting you go back to Southwest Atlanta to kick it with the old guys. And the next thing we know, you're in a Walmart again. Okay.
All right, it's one more thing. What was that? One more thing. What was that?
I have one more thing. Ms. Nelson, it should, well, I don't have to have that new statute on there because it's a year. So we're set. The statute was amended July of 21, so it is relatively new. Go Shubo. Anything else, Mr. Alexandre?
Well, oh my God. My mind went blank.
Okay, I'm gonna assume you're good. Mr. Jordan, anything else?
Nothing further to say.
All right, thank you, Ms. Feely.
All right.
Oh, one last thing. Ms. Tucson, how do we do in reporting in Mr. Alexandre and sober living?
Oh, that's what I wanted to ask you.
Right.
Usually, what happens is, like, if the transport order is on hold, once we submit it, the officer is able to view that they'll be at a facility and contact them there, or the facility will know that he's on probation and get in contact with us there.
Okay. I just want to make sure Mr. Alexandre, doesn't run afoul of reporting, but it's been pretty clear what I put as to how probation needs to work for this guy. And so I trust sober living and DCS will connect. Do we need to tell Mr.
And Mr. Alexandra, you know where probation is in Atlanta, 276 Memorial?
Memorial Drive?
It's like 2 blocks from here.
Memorial Drive in Atlanta.
Yeah.
Not Decatur.
It's not in Decatur, but Atlanta, over there by pretrial, right?
Correct.
Yeah.
Over there by pretrial.
Yeah. I remember what I want to tell you. Now, for future reference, suppose if anything happened in the future while I'm in the program, if I get into a confrontation with like a staff member, or I get into a confrontation with somebody, with one of the clients over there, right? Is there any way, instead of me up and just wanting to dip, can I go to my probation officer and talk to her about transferring to another?
Yes.
program?
And in fact, you show that kind of initiative, you're
Yeah.
going to be doing real well. So
Yeah.
it may be that
That's what I want. Yeah, that's what I meant to tell you.
Okay.
Yeah.
But that means you just need to have your probation officer's number saying, hey, guess what? It's not working well at sober living.
Yeah, all
This
right.
guy keeps taking
I
my
just wanted to
stuff.
have that understanding right there. Okay. Yeah, I'm glad I remember that.
Okay.
All
Good.
right.
All right. Go with this
we
gentleman.
good. All right.
Judge? Hello,
Yes,
the electronic signing of the indictment?
I did that.
Okay,
Thank you for reminding me, but I covered that.
okay, great.
I even wrote it down and crossed it off.
It was a long one, so I didn't remember.
It was. Thank you. I appreciate it. So all that should be left now then is Mr. Campbell.
Do what?
Great. Do you need to spend some time with him?
Thank you.
Okay. Why don't we bring him out so that it was just easier if you need to speak to him in private, you should go back there. If it's just to get him to sign this stuff, you and he can sit at the table.
It's just to collect some signatures.
Okay. Then why don't you slide on over to defense counsel table and we'll knock out this last plea and call it a day.
Thank you, Judge.
Just to give you a warning, Your Honor, and I'm sure you're aware since Deputy McCauley did the previous plea, this will be lengthy as far as facts go, since it's a lot of charges.
Been through it. In fact, Ms. Nelson got me the disposition for Michael Hill so that I could be refreshed at the 1 million counts.
And I do, Attorney Kennedy, do you mind if I have that sheet back? Oh, yes. And I will be dismissing several counts, Your Honor. I can give that now or right before for you, whichever Your Honor.
Oh, let's wait till he's out here and we're on the record.
Yes, sir.
Thanks.
See you tomorrow, Judge.
Thank you. See you then.
Anybody?
Question. That sentence to the because they break the law. Okay, so you don't need that.
No, I think once the transport order, they'll say, okay, we can go. If not, we can amend it, but let's leave it as is. That's a good question, but I thought about it, like, I don't want to, let's just have it say a year.
Okay.
Your Honor, this is Deputy McCollum calling. Do you mind if I step out?
Yeah, I hope everything's all right. You can go in the jury room if that's easier, right through there.
Oh, yeah.
Would it be easier, Mr. Kennedy, if we just, should we take a break or you guys could, I don't want to preclude you from talking, and I know you're sitting here in court rather than where you can speak privately. Do you need more time?
We just went over all the waivers, so I just need to collect some initials and a signature. So
Okay, you're good? No, at the time, my concern wasn't the time. I just noticed that there was some back and forth. I wanted to make sure you and Mr. Campbell felt you could speak freely, but if it's merely the procedural stuff, we're good and he can initial away.
It is the plea proceeding.
Okay.
Judge, I appreciate the court's patience.
I'm glad we are able to move Mr. Campbell's situation forward. Let's hope Mr. Jordan doesn't come back with bad news. You can leave that on his laptop. He'll verify the signatures during the exchange. Mr. Jordan, are we good?
Your Honor, if Deputy McCauley is on the way to the courtroom, if we can just have a brief pause for that, I do apologize for the delay.
Any cause for concern?
She was not aware that the plea for Mr. Campbell was happening this morning. She just wanted to come and speak with me, and also Attorney Kennedy as well. So we may need to put a brief pause on the plea, if that's okay with Your Honor.
Okay. How soon before she gets here? Like she's here in a minute, or she'll be here at 2?
She said that she would be here within 5 minutes.
Okay, I'm gonna go back there. Let's have Mr. Campbell go back in a lockup and then let the deputies know when I should come back out.
Yes, Your Honor, my apologies.
No. That probation revocation, so. Stevens. You know, took your lunch? Come back. So what? I'll take them all to my niece's house. She wanted some rings and Ian. Sister was supposed to be dressing. I don't do bread. I don't know, she was supposed to cook it yesterday. They have it, they didn't. Took it over on Sunday. Is that right? When I'm cooking this weekend? Oh, what? No, that's for dinner, so I don't put up big food. He can eat chicken every day, but I can't. Yeah. Oh, you know what? I got some pasta in the freezer. Seafood pasta. I saw this recipe on TikTok. There's you make your corn, street corn, on some pita with some shrimp. Yeah. Well, that's what I got. I got the tilapia fish. I baked it. Then it's like a lasagna, so it's the mixture is Alfredo sauce, and it's an orange vodka sauce, and then you got put that in with the chopped fish, and then tomatoes, all of that. Look like you're doing That's what I put that up in the freezer. Liver, yeah. I have cat liver, but I'm not gonna eat it. I used to like, who used to sell the livers? I think it's, Popeyes. They used to sell fried livers. Every now and then, it tastes good. I wasn't gonna eat it. Really keep. What you doing? Actually, I'm curious to forget it. She comes in. I'm trying to make how old is she? Take time, take time. He's like that talking. Wow. She's talking to it. Wow. So she's a cook, you like, well, I'm trying to get her. She don't like it either. Yeah. Well, once you get her friends on the phone, they're like, oh, they cook. Okay. So they start, they'll be on FaceTime trying to cook. Okay. Saturdays, I buy pots, so she can measure them, right. Pots, all right, she like it about this house. Come on, I if she wanted to go, she can go. She can go to school or go to the church. She girly. She keeps saying, if you could dress with her. We'll go to the store, she's out over there, right? She's like, oh, please. But she, yeah, you gotta have your own style. Yeah, envision yourself. Good. I didn't know she was. I guess I've been that old. Yeah, she get her little cuts and then on drop stick, why stick? So her friends, everyone try to drive her car. That's how my parents told me to all our kids not to drive sticks. Oh, back in the day, that's what they wanted to do. Try your car. So it was a stick, I can't drive. Oh, okay, that's a good way to deter people. Okay. You think so? You'll be able to drive a lot back. Yeah. Right, really moving on up there, huh? Mm-hmm. Different seating, like. Yes, I was in this. You got through yours, that's a good thing. Time was on the Edwards, I'm like, what girly Tom, girl? Yeah, she in college and everything. So I remember when she was just in high school. Like, oh, why can't everybody raise their kids? You're right about that. I know when I first started, they had like a little group, like a little parent, all the ones that worked at night shift. I think it was Betty Nelson, she worked at night, and I think her aunt would babysit the other kids that worked at night. So they would trade off, but that was a long time ago. That was a good little setup. Yeah. But you know, you got like an auntie, she at home, you know, they gotta work that shift, something like that. How about them? Because I work, you know, everybody got work night shift. I worked night shift 2 years here. I was very good at it. In my door. I was living in Plea. I had to go all the way
and she'll sleep on her couch. She was going to school, Alabama. She'll take her to school and learn. Wow, I had to pick her up.
Ooh, that was like. That's how they used to do it in jail. 4 or 5 of them. But they made it through. I mean, I don't know, time right now, but that's the system they used to have, like the lady. Like, okay, my child was with somehow, you go to have somebody else. They kind of work it out, but I guess, I don't know, maybe people different now. But they keep a little bit. I think that would be a one, where he was raised in a big family. So for 6 years, my job was to pick up all the kids from school, bring them over to our house, and my mom would be the babysitter. Because I work from 6 to 2, so they got out like within that time. The rest of my sisters, they got 5, 6, so that was my job as a sister. So I had to pick up.
You did that right.
Well, 4 of them was at one school. They went to the private school, Catholic church school. Like a church school, what you call it? Yeah, Christian school. So 4 of them was there. One was at another school, but she was close to my job. So I picked her up, and that's 5. And I had the other 4 to pick up.
Okay, just 5 on there.
It was 6 altogether, because my nephew, I had to pick him up, but he was on the way home. All of them went to grandma's house. I said, I did that for 6 years, I didn't get paid. And they're like, girl, that was your job. I said, okay. Because I had the time. But I know you said now, it was a blessing to us. It came to that leave, baby. For 6 years, I did that till they got in middle school or either high school. Yeah, auntie, I remember we couldn't listen to no music. I would listen to Christian music. I would let them turn my radio on, nothing but Christian, so we always sang Christian songs and everything. Yeah, when we got in your car, we couldn't listen to nothing but Christian music.
They still talk to this day about that.
But they know it now, like growing up, and they like, when we get the house, we used to make sure we go in your room, because I had all my stuff in order. If you put it out of order, I know it just, so I'm on her anal. So my niece, she said, I used to purposely go in your room and mess up on me and stuff just to see if you gonna pay attention. I said, I don't know. I never, huh? Yeah, they used to. And I would work, and I worked at the liquor store for some years, too. When I left my regular job, I worked at the liquor store in the evening from 4 to 12. That it was like right up the street, I could walk there. I'll never forget my niece, they all in the bed everywhere. Sometimes on the weekend they spend the night over. And she got me real good. I talk about it now, but she get embarrassed. I said, girl, you did me good that time. What did you do? She used to wet the bed. And so I come home inside the 12, so all of them in the bed, so I just like move them over and get on in the bed. I wake up like 2 or 3 in the morning, I'm soaking wet. Like, oh my God. You know, so I couldn't think if I did it away. And so the first, because I knew that was her, and I'm feeling her, she dry. I'm like, oh my God, I ain't tell nobody, because I ain't know myself. So now I'm like, she dry, she ain't wet, ain't nobody wet. Oh gosh, so down up. And then like maybe a day or 2, I'm cleaning up, sweeping up, look on the bed with pissy drawers under there. I'm like, the guy here, she don't got a change. And I get her all the time about that. You don't be telling nobody that. I said, yeah, you got
She might as well do the thing the way she tried hard.
She don't get up and change and put on some dry drawers, and I'm up there thinking I'm wet on myself. And got back in the, that's the first one I touched. Like, she dry, I'm wet. I ain't gonna tell nobody that, because I ain't know if I did. So after I found out it was her, I know you lied. No, it was just a laugh. She don't like for me to tell it now. I said, yeah, Mickey, you remember that day? I cheated. Oh, y'all tell nobody that. She done rolled up out that bed quiet. Say, yeah, cause I ain't saying no, I ain't saying that. When I found him, then I could talk about it. But if I wouldn't have found him, I would have kept that to myself. She probably woke up and saw you wasted like, oh, she gonna kill me. Yeah, she got me that day. Cause I had potty trained her. And she like, oh, I ain't let her get by with that. And my mom, no, girl. I said, no, she know. She know when she feel that thing. So the girls like they wanted to be. My boy did the same thing. He kept like that, you know. So this is the same thing. Not only that, I trained her in 3 days. You did it in 3 days. My mama didn't do it. I did it. In 3 days, she was trained. But every time she went it, you say, I popped. I said, you know the feeling? When you feel that feeling, get yourself on in that bathroom. And honey, I tell you, no, honey, she be holding and trying to get that, but she did it. Now the boys, they go somewhere and hide. I'm like, Zay, what you up there doing? Huh? You already know. And they was hard, but the girls, they once they get it, they got it. Them little boys, they were hard. I said, you remember them days? What's my time? Oh, yeah, I am. I don't see them now. They gonna move out. They grown. Yep, they grown. But you know what? They didn't really have no. Well, 3 nieces and another baby. Nikki never had kids. Said she was too selfish. She couldn't have them. Nikki in her 40s. Things Zay, I ain't seen him too. Seen him since he was my dad. Ever since 2014. Now I'm in their 30s and 40s.
They all still in the lineup?
Huh?
They all here?
Some of them I hear they're in and out. Last time I talked, like Zay had went up. I think he went to Virginia, stayed up there for a minute. Great niece and great nephew. Feel good, mom? Huh?
What is that?
You said what? You heard that word. Quick question.
And now?
When she said she was gonna go to Jamaica?
Yeah, Thursday. Her birthday is Thursday.
Yeah, she told me that was her trip.
She's gonna fly out as kids. I'm a decoration.
Oh, that's something.
So, I don't know how I'm gonna work, but I'm going, just birthday stuff, come back tonight.
Yeah. Be nice, she gonna be here first.
Tomorrow, last day.
You date? You want me back? You don't know yet? Oh, back. Say what? Hey, yeah. You don't know nothing? Oh my God, did you die?
Look, those stores here, brown.
What you talking about? Okay. Yeah, I'm talking about really cooking.
I mean, I know how to do it, but I don't do it.
Oh, you do know how?
You know, when I was young, big brown. I do butter sandwich, shake the flour in there.
Okay. You do know it, you just don't do it. Now they're lazy. See, when we were growing up, we had a week that you did the cooking. So I got 5 sisters. So you had a week to cook, you got a week to wash dishes, you got a week to clean up. A week, you not no days? It was a week. My daddy didn't play that. Then he come and inspect it. Well, leave no dishes in the sink, no dishes in the oven, no dishes in the refrigerator, allow that. I remember my job, probably 3rd, 4th grade, I had to sweep the house, but back then you had big old house, way, like, yeah, hallway. And my job was to sweep the hallway every day, come with the roof, it was right there, field bricks. Sweep the all back up, we couldn't. All this time you wasted that, but did it at one time and got it right, so that's why now it's simply like, just do it right and get it over. Yeah. Exactly how you want to. But now they, back in that day, they teach you how to do stuff. Before they just did it. And my nephew, like, he just got it, well, it ain't a new part, but it's a new part of him. So he go in there and put some kind of oil into the wrong thing and messed up his engine. And he put oil in there. I'm like, but he's 20-some years old, you don't know that? If it don't say motor oil, you don't put it in the motor. He got the half and half oil that you put in, like the lawn oil and stuff like that. They put it into the car. And somebody had to come over there and blow all of that out. But it messed up his engine. I'm like, how is he 20-some years old and don't know? I thought he got uncles that work on cars and say, when I was like, when they told me, I'm like, he did what? Put some kind of oil in the car, like the motor oil. Like, you know, God, it's going to be a boy. I would think you should. You want some cookies? I'm just going to tell her to cook. What you want her to cook? She ain't gonna cook too much. No, she got it. Yeah. Coughing all over. She got COPD. She got COVID back. So they don't want to grab it. My, yeah, my very, very sick. Sister, she got it. And she said she think it messed up her memory. She has some after effects after that. Well, my brother had it. She was real bad. And she was a diabetic. Now, when they want to get their transplants. Got there, got to the hospital, transferred to another hospital. Yeah, I would really get like 5 years. And then you have to be on the waiting list too, right? Yes, and you get it. Take the pills every day of your life. What time is it coming out? Waiting on y'all, waiting on us, okay. Like 5 minutes away. That was stressful. I had about my hair. 4 people every day. I had a cousin, he was like 40, he got COVID. He went to New York. And I had a, I think an aunt that, but she was in the country, she was older than me. She got, I think one of the young people went to college. But that was at the time it was, you know, nobody knew how it would be contracted.
They live like little bubbles every time anybody come in their house, you just think everybody. She up, but
I don't blame her.
I've been in her house twice and testified. I said, Mike, all right, babe, I'll see you later.
And see, that's why I like being, I got older sisters.
Excuse me, yes, that lady was, is she the sheriff or she the DA?
She'll be in,
Prosecutor. But she on the.
she worked with the state. She was in the morning.
I thought he was on the other DA.
The
Black guy is.
He was substitute for her.
Yeah. The white guy's attorney.
Oh, so let Jordan use substitute for her.
Yeah, they prosecutors. Jordan was in last time.
But he been out earlier today. He was out in the morning.
We waiting on Lord.
Yes, I'll be mindful. I go around my sister. They don't even know where they at. They don't care if they going to the store or whatever. But I think a lot of people did end up getting signed. You got it. I never got it. My husband. I had told him that's what we had. I just got an upper respiratory infection. That's what they told me at first. I said, I really said probably too much. It was his call, but it didn't really like take us everything. So we ended up going to the church and we got tested. And then the doctor had a Zoom call. Person drive from Jackson. He went on my side. Yeah, but that's what we said. I was like, for today.
Seems so long.
But it changed a whole lot of things. And I think like now, everywhere I just talk to, what's their attorney name? She's all the way down in to be. What have you put up?
Right.
Yeah. Like they just, and she said they just over passionate with work and they got to get down here. I said that's everywhere. That's us too. So they can't keep my dog either. She said about 5 of them left her office. One of them, but they go into like insurance places. Yeah. I have one. Yeah, attorney. Yeah, right. That one. Which way?
She just said she made some. I'm new.
I can't be able to. She cooked now, she cooked from scratch. I know that.
Cook from scratch? You be good.
If you come over, I'm not yeah. Yeah, I'll leave her.
If you want, she just said it.
I do, but she know how to cook, she just don't want to.
I just don't want to. I'm like, no, you know, it needs to go. My life. Bring it in the face. Why that? That's all right. I gotta go figure out what I'm gonna eat. You good?
All right, Miss Avila.
Take care. Yes, ma'am. It's all right. See, I gotta go to Broadway, your court line. What? Where else? Oh, that's what, you know, what you're saying over there. So I'll go with here. But I ain't that's your court line.
Well, I'll go over there when we done.
Yeah, come on. Can't believe me. I got you.
Solace.
Yes.
That's what you were.
This is what I inherited.
We ready?
Yes, we're ready for Judge McBurney to come back out. We do need to speak with him.
I'll go with you to your office and maybe see if I can identify the binder.
Okay.
Next to him is some office. Sorry, Julie.
It's no problem.
Make sure all the cell phones are off at this time.
But when you have this case tag under on evidence.com. Do you remember?
Yeah, I don't think there was an ID number for that one. Let me make sure.
It's okay. I'll just start looking them up by the case number and see if I can merge them in.
Gotcha, okay. Reed, do you still have that email from evidence.com with the case number in it?
I think so.
Okay.
The court will now come to order, remain seated.
Ms. McCauley, have we taken all the time you need?
Yes, Judge.
Excellent. Are we still going forward, Mr. Kennedy?
Judge, unfortunately, it looks like we are not. We would need to reset the plea and I guess potentially put us, well, I'll just say we're not going to move forward at this time.
Okay. Does Mr. Campbell know that?
He does not.
Okay. Do you want to talk to him first, or do you want this to come out in this large group public setting?
It can come out in the public setting. Your Honor.
Okay, great. Let's bring him out. Mr. Kennedy, do you want our discussion taken down? I've got a court reporter on here. I'm not sure exactly what we're going to be working through.
Yes, sir.
Okay, all right. Well, let's go on the record then in 19 SC 166417. It's State versus Jaquante Campbell. Let me make sure. I assume everyone's ready, but they've hopefully been at ease. Ms. Rivers, are you with us? Yes, she says. Okay. Ms. Jackson, you are free to go. I appreciate you being here. I thought we had one more matter to take care of with your input, but it's not heading in that direction. We will see you hopefully tomorrow at the call of the criminal calendar.
Thank you, Judge.
And same with you, Ms. Tucson.
Okay, thank you, Judge. You guys have a good one.
All right. So we're on the record in Mr. Campbell's case. About a half hour ago, we were on the verge of taking what I understood to be a negotiated plea. But things have changed and I need to understand what's happened. Mr. Campbell needs to understand what's happened and we need to chart out our next steps. I know this, Mr. Campbell will be on our next consolidated criminal trial calendar, which is the weeks of April 10th and 17th. Given the length of time Mr. Campbell's been in jail, he'll be towards the top there, I suspect, although we're pulling that calendar together today and tomorrow, and we'll push it out soon and we'll work through that. So with that said, why don't you start, since you told me this was a plea?
Yes, Your Honor. We were very close to a negotiated plea. We had the number essentially worked out. Deputy McCauley did reach out to me and made me aware of the last time that this case was presented for a non-negotiated plea. I was made aware of the number that was discussed at that time. Your Honor, given that information and given that Your Honor did essentially state that you would not accept that number in 2020. We did think it was appropriate to come back to the table and negotiate a number that we believe that would be accepted as far as a negotiated plea went. Deputy McCauley did give us a copy and I will make sure that Mr. Kennedy gets a copy of the last plea transcript for the non-negotiated plea.
When you say plea transcript, and I'm sorry to interrupt, meaning Mr. Hill's plea or the transcript of Mr. Campbell's almost plea, because we almost had a plea back in courtroom 1D, and then Mr. Campbell decided to step back from that.
My understanding, Your Honor, is that since they took the plea at the same time, that it contains both.
Okay.
Mr. Hill's plea transcript and Mr. Campbell's almost plea transcript.
Got it.
Being contained in the same document. Also, Deputy McCauley does have all of the discovery that we were discussing earlier.
Look at that.
All of it. So she will be giving it to me and I will make sure that Attorney Kennedy has that on a hard drive. It's a lot of video and a lot of different files. So I will make sure he has that within the week. Attorney Kennedy said that he was going to supply us with a hard drive so that we would be able to place everything on there and not have to go through evidence.com. So that's essentially what has just happened, Your Honor. I apologize to the court. I was not aware that the last number was, I believe, 8 to serve. Was it 20 to serve 8? 30 to serve 8, Your Honor. So we did want to, I believe that Attorney Kennedy and I still may come to a negotiated offer, but I wanted to make sure it was in alignment with what the court would accept as well. So we wouldn't be placed in the same position as we were when the first plea almost went through.
So thank you for explaining that. I think I understand it. I want to try to recreate where we were. It was been in 2020. It was a while ago. Mr. Campbell had Mr. Bowles, I think is his lawyer. And what you're saying, no? Mary Beth Snyder. Right. So it was a conflict defender situation. So poor Mr. Campbell bounced from Mary Beth Snyder to a number of folks. And I think we got you involved, Mr. Kennedy, because we agreed, the C2 universe agreed to step back from the case because Mr. Campbell's lawyer would, for the foreseeable future, be a conflict defender who is on the YSL case and wouldn't be around to help Mr. Campbell. So you have agreed to step in, and for that, we are very appreciative, all of us. So the plea didn't go through. It was negotiated and was going to be 30 to do 8, and I blew it up, or it was non-negotiated. And you're welcome to chime in, Ms. McCauley. You and I were all the people here, you, Mr. Campbell, and I were the only one, and maybe friends of Mr. Campbell were the only ones here.
It was originally gonna be 30 to serve 8. You did not like the 17 years on probation, so you were gonna suspend a portion of that, but you never got around to what the announcement was on the suspended portion of the probation. But you said specifically that you didn't like the 17 years, and then you went into a colloquy about how you felt that the number should have been higher, but because it was a recommendation, a recommended plea, you weren't going to disrupt the negotiations at that time. Mr. Campbell went through the plea colloquy, and Ms. Snyder reported out in some transcript that he needed time to think about the court sentence. And used it actually down to come back, I think it was January 17th is the date that's in the transcript. It actually came back on January 21st on another final plea calendar, at which point it was formally rejected on the record. And if I remember correctly, and I texted Ms. Snyder to confirm, but at that point, I think it was announced that that offer was no longer available.
Okay.
From the court.
Well, I don't make offers, so it wouldn't have been.
The 8 was, you felt the 8 was too low, and that it should not be returned the second time.
Okay, so
That's my recollection.
fine, and I'll look at the transcript too, but what I fussed about, it sounds like were two things: that 8 seemed like not enough years in custody, and then 17 seemed like too many years on probation. And I'll repeat that. I'm not a fan of infinite probation sentences, but that doesn't mean it can't be recommended. The math doesn't quite add up. Then was it 5 suspended after the 17? Because 8 plus 17 is 25, and you're saying it was 30 to serve 8.
It was 30 to serve, and I did not read this portion again when I came in about all the merger and vacate issues that existed on the indictment, because there are several.
Sure.
And I want to say there is a 5 suspended somewhere on a firearm charge.
Okay, that would make sense. I mean, that's typically what we see, that there's some possession of a firearm in connection with the felony, and that's 5 and it has to run consecutive, and it's often suspended. But
Actually, now that I'm remembering correctly, I think because of his prior, if he's got possession of a firearm, by a convicted felon.
okay,
That's what it is.
it was that, and that was one that was going to run consecutive but be suspended.
It has to be consecutive.
Okay.
I think under the third section.
So that got you from 25 to serve 8 to 30 to serve 8, but those last 5 were suspended. Be that as it may, what I had said was, I'm probably not going to impose that much probation. I'll roll with the 8. And Mr. Campbell in January of 21 said, no, thank you. And so then he's been stuck as he has transitioned through no fault of his own, from conflict defender to conflict defender to conflict defender. We put a stop to that. Mr. Kennedy is now appointed / retained by the county, so he's not going anywhere. He will be Mr. Campbell's lawyer. Mr. You are and will remain his lawyer. You're going to get more discovery, it sounds like, quantity that fits on a hard drive. I don't know that any of it changes the overall picture. I'm remembering the basic thrust of the state's allegations, and it's a series of these burglaries and whatnot, entering autos. So this will be maybe additional video evidence behind it. I never got the sense, this is privilege, you don't need to get into it. I never got the sense that Mr. Campbell was saying, you've got the wrong guy. It was more, I don't like those numbers, and so I guess I'll roll the dice and see what happens at trial. That was the thinking in 2021, and it might have made sense if there was going to be a trial in 2021. Everything shuts down, we get back out. He effectively has no lawyer for a long time. Now you're in the mix. So you've just received a lot. Tell me what the right next steps are for Mr. Campbell. Should we take the case off this April trial calendar because you need to digest this discovery and talk with your client in a meaningful way?
I would feel comfortable taking it off at this time, Your Honor.
Okay. I don't want this case to languish, and I'm not suggesting you've contributed to that at all, Mr. Kennedy, but I think what I'll do is put it back on a status calendar. That's what we use to make sure you've got all the discovery, which you will have soon when you get that hard drive, to the state and then get it back. And at that status calendar, always can take a plea, negotiated or not. But you'll be able to say, I do have all the discovery, and not only that, but I've had a chance to put my arms around it. I feel like I know what's going on. You're going to decide for yourself whether that has improved your view or hurt your view of Mr. Campbell's chances if it goes to trial. But you'll be in a better position to say, hey, we should fight this. If the offer is 8 or 10 or whatever it is, that's crazy. Let's go to trial. Or you don't really have a lot to negotiate here. And let's just see what best we can get, to include a non-negotiated plea where the state comes in here and you come in there and we see what happens. We are at the point where there is no right to withdraw the plea. That has happened. Mr. Campbell exercised his right to withdraw his plea way back in 2021. So any plea that we take, Mr. Campbell, assuming I accept his plea, my sentence is his sentence, and there's not a wait a minute. I was all right with the 8 or the 5 or whatever he was hoping for, and we'll see how that plays out. If he's not interested in taking a plea, I respect that, and we got to try it. And I'll probably put it on another one of those consolidated criminal trial calendars, but I'll take it off the April one just so you have a chance to climb the rest of the discovery mountain, because it sounds like you'll get it.
Okay, thank you, Your Honor.
No, I know it is. I'm remembering this plea, and Ms. McCauley had this chart. She handed it out to everyone. It is a series of interconnected allegations, but each one is a separate case. And just laying the factual foundation for a plea, and this happened, and this happened. And unfortunately, so much time has passed. I don't think it would be, if there's a plea, appropriate to say, hey, we all agree that the factual foundation was laid in December of 2020. It was, but we'd need to hear it again. So, Mr. Campbell, do you have, a lot has changed. I saw you this morning and I was like, hey, maybe it's going to be a plea at long last. You get some closure. These victims get closure, and people can move in different directions. That's not happening today. Do you have questions about anything you've heard people saying? I need you to answer out loud.
I mean, the part where you said I like that you were saying I never said that I didn't commit the crime. I never said it.
Well, I may have spoken inartfully. What I meant to say was when we were having that conversation in late 2020 about whether you're going to plead guilty or not, it wasn't what we call an Alford plea, for example. Miss Snyder didn't say, well, Judge, Mr. Campbell's going to plead, but it's an Alford plea. He won there, but he would rather enter this plea than go to trial. I'm not putting words in your mouth. You are free to go to trial, and your defense can be whatever you and Mr. Kennedy decide your defense is. I have not already concluded that you're guilty of anything. You remain with a presumption of innocence in your favor. You've just been sitting around in jail for a long time, and we need to get some closure for you. My thought was getting it on that trial calendar for a couple weeks, in a couple weeks, would help focus everyone, and it has. But we learned by getting folks focused that your lawyer didn't have all the discovery, and he's entitled to it because you're entitled to it. So he will look through that, and then we will get together again to find out, now that Mr. Kennedy has looked at it all and shared with you his impressions of it. Hey, Mr. Campbell, here you are on video doing X, or no, look, the guy on video looks like McBurney, doesn't look like Campbell. That's a great defense. Let's play that video to the jury. He'll look at it and he'll make those decisions and talk to you about it. After you've had those discussions, we'll get back together and I'll find out, is it a plea? It is. It's a negotiated plea. It's a blind plea. Nope, it's a trial. Then let's do the trial. I'm indifferent as to how we do it. Where I am getting increasing heartburn is that there is a young man who has been in jail for going on however many years, 1,000+ days is, who hasn't had a trial yet. And that's not how the system's supposed to work. You're not alone in that situation. So I'm anxious to push it, but I have to push it in a way that's consistent with your lawyer being ready. And he's been scrambling to get ready. He is newer to the case. And he didn't even have all the discovery, but he will get it. And when he and you say, we're ready to go, then we'll have that conversation, trial or plea. Does that clear it up? I in no way was I saying, I know you did it. I don't know that. You'll tell me you did it if you plead guilty, or you'll say, let's let the jury decide what happened. And the jury will say, state proved the case. State didn't prove the case. And we'll go from there. Does Mr. Campbell face any recidivist situation if he goes to trial?
Your Honor, I do believe that there was a previous recidivist notice that was filed. I don't believe that Attorney Kennedy has been served with that yet, and I will make sure to.
Well, if it's in the docket, it's in the docket. So it's been served, doesn't matter on which lawyer, but that's just another thing for Mr. Kennedy to be aware of and to discuss with Mr. Campbell, that the plea was not pursuant to any recidivist notice. It was, okay.
That was one of the contentious issues that we discussed.
Well, that's how we got to 30. That's why it had to be 30.
Well, it had to be, but it was the 8 and it was to serve day for day. And I want to double check to make sure on the 30 that the burglary, he's got a prior conviction for burglary, and I don't know if that was. I don't know if it, because I think it has to be 2 or more burglaries.
Well, we don't need to sort that out today, but I'm flagging.
It does impact the plea.
Okay, so I'm just flagging for you, Mr. Kennedy, as you're talking with Mr. Campbell, depending on how all this plays out, that recidivist notice can make life even more complicated after a trial. So everyone should just proceed with that in mind. So, Mr. Campbell, again, I just want to get your case resolved, however you elect to do that. Work it out with a plea, negotiated or non-negotiated, or have a jury work it out. So I'll get you back here. Do you want to take a look at the discovery? I don't mean look at all of it, but get a sense of how much it is and say, could we have a status conference 2 weeks out or 6 weeks out? Or should we just set a date now, because that will cause you to prioritize this case? What I don't want to do is set a status conference and you show up saying, Judge, it was 82 terabytes of data. I'm still looking at videos from the first burglary.
Judge, we could set a status conference. What kind of a time frame were you?
That's what I'm asking, is you tell me what time frame you think is reasonable. So here we are, March 21. Let's hope any reason why you wouldn't have the discovery by the beginning of next week? I don't know that process.
No, Your Honor. If anything, by this Friday, we will make sure that Attorney Kennedy has the discovery. We have it prepared. It's just he needs to.
You need the vessel in which to put it. When are you planning on being able to get the hard drive to them?
I can do that this week, Your Honor.
Okay. So let's assume you've got all the discovery by Monday, the 27th. You know your schedule. I don't. A month, 2 months. I don't want to say 6 months, Mr. Campbell. 6 more months. So he needs you to be up to speed, though, so that you can visit him and say, how do we work through all these videos of you doing X? Or I don't see you on the videos. This is good stuff.
I hate to ask for 2 months, but it looks like a multitude of discovery and digital media form, and I'll need to review all of that and see what's pertinent and what isn't, and if need be, go over some of that with my client as well.
Okay. Why don't I don't have dates out in Ms. Nelson well, and I'll work with her, but we will aim for a status calendar in early to mid-May. So it's not quite 2 months. It'll be more than a month. My request of you is that when that calendar is published, and they're usually published a couple of weeks in advance, if you know when you get that, there's no way I can have closed the loop with my client so that it's a meaningful status conference. Are we working it out, or is it going to trial? Then tell us, and we'll bump it again. But I'll aim for early to mid-May.
Okay, thank you, Judge.
All right. Ms. McCauley, the transcript that Mr. Jordan has, that is sitting in the docket. That's how you got it? Okay, so I can educate myself on that. All right. Anything else from the state?
Nothing further from the state, Your Honor. My apologies to all parties involved. I do apologize for the delay. I apologize to Mr. Campbell. I know he's been in custody for quite some time. So Attorney Kennedy and I will be working really hard to finally close this case out.
Okay.
It's not.
Well, you know what? It's a collective effort to get it moving forward. I'm glad that the panic attack about a possible plea got Ms. McCauley to finally connect with you. Because I know you've been trying to see, hey, any idea where there's other discovery?
I sent an email, but it was also incumbent upon me. I probably could just gone up there to reach.
You could have go to the rare air of the higher floors if you have elevator access. Mr. Campbell, any questions? Okay, Mr. Kennedy will be out to see you soon. My guess is it'll be several visits. Mr. Kennedy, if you are sharing video with a client who's in custody can be complicated. I don't know how it works at Cobb. You'd know better because I think your practice is more up there.
Actually, Judge, it's fairly simple in Cobb County. The judge
Excellent.
sends 24-hour notice to set up a contact visit in a conference room, and
Perfect.
Can facilitate that.
Good. Then let's keep Mr. Campbell in Cobb because that'll just make it easier for you as you're processing it to say, hey, we need to look at this video. This is a bad video or a good one, whatever it might be.
Okay.
All right.
Thank you, Judge.
Thank you all.
You sent me that email I had bronchitis, so I
Oh,
apologize.
it's
I got
no
it.
problem. Because I know it was months ago. Jay.
It was, and then that's it. I apologize.
It's no problem.
But I want to.
Thank you, Ms. Rivers. You do not need to come down here for the rest of the day. You're on mute.
Yeah, I was actually on the road this morning and turned back.
Well, I'm glad you were able to log in on time and we got some of this stuff done. I will see you online tomorrow.
Yes,
All right. Thank you.
have a good night. Bye-bye.
Bye.
Not, I was very